Bonjour tout le monde. Welcome to our committee, Indigenous and Northern Affairs. Today we are going to begin our review of a bill, Bill C-92, the Act Respecting First Nations, Inuit, Métis Children, Youth, and Families. And before we get started, I want to just let the committee know and our guests that unfortunately we've had administrative glitch, and therefore we don't have the name tags prepared and we don't have documents in front of us like normal, but the transportation, the mail bag is to arrive very shortly and things will go back to normal. But for now, I'm going to ask every member to clearly state their name and position because we don't have it in front of us, and I'd ask members to just jot it down because we won't have name tags for a while. And this committee plays an important role in the government's, in Parliament's goal of reconciliation and understanding the truth. We recognize the lands that we hold the meeting at, not just as a formality, but to ask Canadians to reflect. Whose land was it before settlers came? How does Canadian history work, and why are we in a position now where settlement was in some areas 400 years ago, and yet we still have many, many issues to address? So it's an important process for all Canadians, but especially here in Ottawa, for those watching. We are on the unceded territory of the Algonquin people, and we thank them for what they've done for all of us. So on to our presentation, and we're honored to have Minister Seamus O'Regan, who will open up our discussion, and he'll present his remarks, and then we'll have an opportunity to delve into the bill by having a chance to ask him some questions. So whenever you're ready, Minister, if you could, perhaps you could introduce your team that's there with you. We know who you are, but we'd like to know the others as well. Over to you.
Madam Chair, I take it as probably a very good indicator of how closely we've been working that I know them all only by their first names.
All right, well, why don't we start with you?
Good morning. My name is Isa Gros-Louis.
Gros-Louis.
Can't hear
Revelation to me.
Let's do it again.
Okay, good morning. My name is Isa Gros-Louis. I'm the DG responsible for Child and Family Services at the Department of Indigenous Services Canada.
Thank you.
Bonjour, good morning. My name is Jean-François Tremblay, also known as JF. I'm the Deputy Minister at Indigenous Services Canada.
Good morning. My name is Joanne Wilkinson. I'm the Assistant Deputy Minister for Child and Family Services Reform with Indigenous Services Canada.
Good morning. Laurie Sargent. I'm Assistant Deputy Minister of Aboriginal Affairs portfolio at Justice Canada. Thank you.
All right, welcome. I think we're ready. Anytime you are.
Thank you, Madam Chair and colleagues, for the invitation to appear before the committee today to speak to these important and necessary changes to child and family services for First Nations, Inuit, and Métis people. Allow me to start by acknowledging that we are gathered on the traditional and unceded territory of the Algonquin people. Today, my team and I are joined together, and we will be glad to answer questions shortly. Protecting and promoting the well-being of Indigenous children and families should be the foremost priority of the federal government and governments across Canada. However, that has not always been the case. Every day in Canada, Indigenous children are separated from their families, communities, languages, and cultures. Too many Indigenous children end up in care away from their communities. These already vulnerable children are forcibly taken from their homes without their parents' consent, and all too often deprived of their culture and identity, as well as the community supports that ensure their long-term well-being. I think we can all agree that the current system does not work for Indigenous children and families, and that we cannot perpetuate the status quo in a child and family services system that has been rightly called a humanitarian crisis. Something is seriously wrong when Indigenous children represent only 7.7% of all children under age 15 and yet make up 52% of children in care in this country. Paternalistic policies keep these children isolated from the people they love. Too many young lives have been severely damaged and in some cases tragically lost. This is precisely why Bill C-92 takes an entirely different approach. We have before us a bill that represents a set of national priorities that the government and Indigenous groups worked on together. Principles that put the child first, that enshrine the importance of culture, community, and family in the well-being of that child, and that uphold the dignity of the family and of the child in any dealings with the child and family services system. Our vision is of a system where Indigenous peoples are in charge of their own child and family services. Something we recognize should have been the case a long time ago. Bill C-92 will finally put into law what Indigenous peoples across the country have been asking of government for decades, that their inherent jurisdiction be recognized and affirmed. Should Bill C-92 be adopted, Indigenous communities could exercise partial or full jurisdiction over child and family services. Because a one-size-fits-all approach does not work, it would be up to Indigenous peoples to tailor the system to match the needs of their communities. And we are committed to working with individual communities to make sure those services are tailored to meet their needs. The bill flows from an intensive period of engagement with First Nations, Inuit, and Métis leaders, communities, and individuals, as well as the provinces and territories. Since the emergency meeting convened by my predecessor in January 2018, there have been extensive meetings and consultations across the country in an effort to get this right. Even in the weeks preceding the introduction of the bill, we were incorporating the suggestions of Indigenous groups, provincial and territorial partners. For me, the truest sense of our efforts came from a statement by Senator Murray Sinclair that our approach, quote, should serve as a model for implementing the Truth and Reconciliation calls to action in a meaningful and direct way, end quote. That doesn't mean the conversation starts there or stops there. There are no closed doors to our Indigenous partners or the provinces and the territories. This bill and the children it aims to protect are only served if we collaborate and ensure their best interests. Also, I am not suggesting we've achieved perfection with this legislation. I am the first to admit there's still room for improvement, and I welcome this committee's input. C-92 was built on what Indigenous peoples and child development experts have told us is required to protect children, to get them off to a good start in life. Under this Act, Indigenous Child and Family Services will put the child first, consistent with the United Nations Convention on the Rights of the Child, the Truth and Reconciliation Commission of Canada's calls to action, and the United Nations Declaration of the Rights of Indigenous Peoples. This legislation sets out principles to ensure Indigenous children and their families will be treated with dignity and that their rights will be preserved. For instance, children could not be taken into care based on socioeconomic conditions alone, as is often the case now. And instead of responding solely to crises, Bill C-92 prioritizes prevention. It promotes things like prenatal care and support for parents. Both frontline workers and academics have told us that preventative care is the best predictor of child success and positive development. If circumstances dictate that interventions are needed, an Indigenous child would only be apprehended when it is in the child's best interests, and priority would be given to the placement with the child's own family or community and with or near the child's siblings. Under C-92, when an indigenous group or community wishes to exercise their jurisdiction over child and family services and have their law prevail over federal, provincial, and territorial laws, the Minister of Indigenous Services Canada and the government of each province and territory in which they are located will enter into three-way discussions around a coordination agreement. If an agreement is reached within 12 months following the request, the laws of the Indigenous group or community would have force of law as federal law and prevail over federal, provincial, and territorial child and family services law. If no agreement is reached within 12 months, but reasonable efforts are made to do so, the Indigenous law will also have force of law as federal law. In practical terms, this means that should a government not act in good faith during a negotiation of a coordination agreement after 12 months of negotiations, Indigenous child and family services law would have precedence over provincial law. To promote a smooth transition and implementation of Bill C-92, Canada will explore the creation of distinctions-based transition government structures. The co-developed governance structures would identify tools and processes to increase the capacity of communities as they assume responsibility over child and family services. We also know that funding needs to be part of the equation for this act to have maximum impact. We cannot presume that the funding models that have supported the current broken system will be what Indigenous groups want while exercising their jurisdiction. Those models and levels should be discussed and designed through the coordination agreement Bill C-92 is built on, or Bill C-92 designed through the coordination agreement process. We pledge to work with partners to identify long-term needs and funding gaps. We are committed to strengthening the bill as it makes its way through Parliament. It is essential that we work collaboratively and effectively to get this done. The necessity for this legislation goes well beyond partisan considerations, something I think that we can all understand and agree. What matters is that, at long last, we are taking substantive action to overhaul the system, moving away from paternalistic policy failures of the past. Bill C-92 is a concrete demonstration of our collective determination to forge a renewed relationship between Canada and Indigenous peoples, one built on respect and the recognition and affirmation of rights. This proposed legislation is designed for a better future for Indigenous children, for their families, and for the communities the bill promises to support and protect. Ultimately, that is a better future for all of us. And for that, I hope I can count on your support. Thank you, Madam Chair.
Thank you. We open questionings with the Liberal side. And for those that are not bilingual, put in your headphones because we're going to begin with MP Yves Robillard. Go ahead. Oh. I think you can. The minister's looking for. He's all tied up. Me too.
I'll get to it eventually.
Where the heck does this go in? All right, I think we're ready.
Is that okay?
Monsieur? Yeah.
Merci à
Good morning, Minister. Thanks for your testimony this morning, and thanks for the work you've done on this bill as well. My question, of course, will be asked in French. I'd like to pick up on the process that was used to develop this legislation. Representatives of Aboriginal communities who have testified before this committee often tell us the following: don't take decisions about us without us. Could you tell us a bit more about the consultation process which was undertaken before the draft?
Across the country, people talking about this, people giving us an understanding of what exactly it will mean. It's met more often than not with disbelief. I spent quite a bit of time this week in Manitoba and Saskatchewan and British Columbia. Their attitudes towards the proposed legislation, C-92, is mixed. I think it's fair to say, and I look at my colleague Robert, that in Manitoba there seems to be not a belief that we will actually do this. They don't believe that we will actually come forward with this legislation. In British Columbia, they've certainly been more forceful. They've helped us along. This is the legislation that they've been waiting for. Many of them have built up capacity on the ground, where they are already looking after child and family services legislation within their communities, so that they're anxious to have a national blanket that protects them within federal law, and that will allow others to reach the same capacity as they have. But in other areas, where the province has been more heavy-handed when it comes to youth and social services, such as Manitoba and Saskatchewan, there's greater trepidation about whether or not this is real and meaningful. And we've spent most of our time assuring them that that is the case. In Manitoba, for instance, they're introducing something called the Bring Every Child Home Act, BOCHA. And we are encouraging legislation from the ground when it comes to child and family services. What we're pointing out to them is that what we are proposing with Bill C-92 actually works concurrently with what they want to develop on the ground. That is unique to their circumstances, and that it fits nicely with what we want to do nationally. Sometimes when in dealing with a number of Cree women who were confronted with the idea of child and family services and taking it back to their communities, they rightfully said, when they walked away, that I'm walking away with more questions than I had. And I saw that as a good sign. Your groups are about to develop your own child and family services based on the wants and needs and the capabilities of your communities. And we are providing you a shelter within the federal framework. And that is exciting. That is exciting. Ultimately, because it will be more effective. We have effectively doubled the amount of money for child and family services over the past 2.5 years, at somewhere up to $2.1 billion. 1.2 billion dollars. It's a substantial amount of money, and that money remains there. The difficulty is that 80% of the funding that we carry on through the provinces and through agencies goes towards protective services. And that is an ironic phrase that basically refers to the security and everything that surrounds the abduction of a child. So 80% of the budget is about the abduction of the child and the associated costs, which are many. So there is a hope, too, that there will be more money freed up there because the communities themselves and we are hell-bent on making sure that we drastically reduce the number of children who are taken from their families. And that we put it, over time, that we put an increased light on preventative care and prenatal care so that we never reach that position again.
Un aspect essentiel de ce
Now, a major part of this bill is the principle of the best interest of the child. Could you give us a more detailed explanation of what that means? What does it really mean in the context of this bill, and how will it be applied on the ground? Well, the bill states that the main thing is the interest of the child. That's something that's understood by the provinces and those working in the child welfare system. It's very, very important in this legislation to make sure that the interests of the child are protected. This is what the groups we've worked with over the past months have said. We also added the issue of cultural continuity, as you know, and also a substantive legality. Now, the importance of that really is to look at the interests of the child. Now, if you look at clause 16, for example, which sets out the process, it says that in the best interest of the child, it's better for them to be kept in their culture, kept close to their family, and that they're able to have access to their parents as well and their community. So that's really the context in which the best interests of the child are considered. Could you add something? Well, I think it's important also to point out that this concept is huge. We'll make sure that it will be implemented by the territories, the provinces, and Aboriginal peoples themselves. Now, we refer in the bill to national standards, and these standards will make sure that, at a minimum, these standards will be implemented countrywide.
To MP Kathy McLeod.
Okay. Thank you, Minister, for joining us this morning. And, the Conservatives certainly agree as we voted at second reading. We don't believe it's a partisan issue. So, mostly we'll be looking at sort of technical concerns and clarification as we look at this bill in depth over the next number of meetings. So I think, I certainly wanted on the record that for far too long, things have been very tragic in many communities, and this will hopefully, if it's done properly and not rushed, provide clarity. I do want to, before I sort of start into my technical questions, when you use the word abduction, I know that we have hardworking social workers across this country. We have where communities have taken on child protection services where they have to, in the best interest of the child, move them to other care. So for you to use the word abduction, I think what you did was insult social workers and child services organizations, including Indigenous organizations across this country. So could you clarify that the wording, why did you use the word abduction as opposed to what these agencies are trying to do, which is in the best interest of the child?
Yeah, no, it's not a word that I use easily, as my mother has been in similar situations as a nurse in the North in which she had to forcibly remove children from families.
So you're calling her a kidnapper?
No, what I'm
That's
saying
what
is...
abduction means.
Yeah, no, I'm aware. I use the word abduction quite purposefully because that is from the point of view of the family. And that is what they see. And it's that family that's my motivation at the moment. With all due respect to my mother and her nursing colleagues, my motivation at the moment is the family. And what the family sees is an abduction.
Well, with respect, Minister, I think using that word there unfortunately is cases where children have been removed in the past, and by calling nurses and social workers basically kidnappers, I find it very offensive. Anyway, to get into the more specifics of this bill, and I think we've had a conversation about this before. And I think it's best if we use an example. So in, let's say there is in Alberta a Métis child who lives in Calgary, who has no connection with their community, and there has been no there has not been an agreement of any sort made in the past. What this legislation does is impose on the Alberta government federal legislation that might be different for Indigenous versus non-Indigenous children. So all of a sudden, Alberta government will have this legislation in terms of requirements around how they deal with a Métis child that might be living in Calgary, or you even have gone as far back as putting prenatals in here. So let's say you have a mother. What's that going to mean for the province of Alberta when they have a piece of federal legislation that states they need to be very careful about? Can you tell me what that clause will do in terms of Alberta? So the prenatal clause is providing a prenatal service. I think we can all agree with preventative service at best interest before the child is born, and the provision of the services is to be given priority over all other services. So you have a pregnant Métis woman living in Calgary. What is that going to require of the province of Alberta?
I'm happy to answer this question. So this clause is on a voluntary basis. So obviously, prenatal services cannot be imposed.
How can you, in terms of legislative, you have something in legislation
Yes.
that requires something. I don't see the word voluntary. So how is it all of a sudden a voluntary?
It's not voluntary on behalf of the service delivery person. So the service will be offered to the mother, but it's voluntary in terms of whether the person wants to adhere to the service or not. So the service will be offered to the mother.
What service? So what is Alberta going to have to do that they're not doing already under this legislation?
So offer prenatal support. So if we take an example of a person that may have a drug addiction while pregnant, it would obviously be flagged in the system. And then services for drug addiction and recovery would be offered to the mother while she's pregnant. Now, that's where I'm talking about voluntary. So it is, it cannot be imposed on the person. So now it becomes a choice of the mother whether she wants to take the offer of the service provided.
And I don't have any trouble with it being choice, but I guess what I'm trying to drive at is is it correct that this bill, in terms of the provinces where jurisdiction is not drawn down by communities, it then all these clauses then apply to the province?
That's correct.
That is correct. Okay. I understand completely where a community has drawn down services, both for on and off reserve, or other circumstances. But what we have here is clearly provision of health care is under provincial jurisdiction, child welfare services is under provincial jurisdiction, and where a community is not drawn down services, all provinces and territories are now going to be have to sort of decide what does prenatal care mean. When is that accurate?
It is accurate, and there are some provinces, from what we understand, doing consultation that already consider these issues. So whenever there's a case being flagged in the system, Some provinces will provide wraparound services to the mothers. Some will have one-on-one services. So that's what we're talking about.
Just to give you an example on this quickly. We did add in the legislation the terms minimum standards for the standards that we have in the legislation, precisely because some provinces said that in some cases they may actually go over those standards and offer more. So they didn't see it as necessarily. So there's already a system out there in provinces who offer prenatal services. So it's not, we're not starting from scratch.
No. And first of all, I certainly am very familiar with what is being offered in provinces across this country. What I am wondering about is, do you have a compliance with the Constitution? Have you had, and can you provide us with any letters from the Justice Department that say this is all consistent and compliant with the Constitution? We're not going to end up in courts like we have in other cases. I absolutely believe in preventative services and appropriate prevention. Certainly this is minimum standards in my perspective. But what you have done is you have created, you are compelling the provinces in a way that I'm not sure constitutionally you can do that, especially around the delivery of health services. So do we have any letters from Justice that will support that this is
I would
consistent?
say we have authority under 9124, and we think that it's also embedded in the Section 35 of the Constitution, but I would like Justice to answer that.
We do have a representative from Justice, but we've run out of time, and perhaps one of the other members will follow up on your important question. So we are now moving to member Rachel Blaney from the NDP.
Thank you, Madam Chair, and I'd like to share my time with Georgina. I'm just going to ask a question or two first. So I'm always happy to have a conversation about how Indigenous children in this country matter. I think that's always an important thing and something that this country has certainly not had enough conversations about, that and the family core. My question to you, Minister, is I'm a strong supporter in the Spirit Bear Plan. And I'm sad and disappointed that this government is not endorsing it and supporting it. It basically asks for Canada to immediately comply with all the rulings by the Canadian Human Rights Tribunal, which I believe now 7 times has come back and asked the government to finally comply, which this government has not, sadly. It also asks that the Parliamentary Budget Officer publicly cost out the shortfalls in all federally funded public services provided to First Nations children, youth, and families, that the government consult with First Nations to co-create a holistic Spirit Bear plan to end all of those inequalities, which this legislation simply does not do, and that we look at what the core issue is on this, which is systemic discrimination. You know, if we talk about that in this place, we need to be mindful that our systems are built on a colonial system that have had impacts that are felt today. And so this also asks that government departments undergo a thorough and independent evaluation to identify any ongoing discriminatory ideologies, policies, or practices and address them. And finally, that all public servants, including senior level, receive mandatory training to identify and address these ideologies, policies, and practices. So I guess my question is twofold. The first part is, if Indigenous children matter in this country, why is this government not supporting this plan? And 2, why has the Human Rights Tribunal come back to this government now 7 times because of lack of compliance to the agreement and the judgment that was made?
First and foremost, since I took this position, I'm determined to make sure that we help the individuals who have been affected and not the agencies who sometimes represent them. I'm more interested in going to the individuals and not the agencies, which hasn't been done in a bit. But I'm determined to do it.
So that doesn't answer the question about why you guys have not, why the government has not obeyed the Canadian Human Rights Tribunal, and why 7 times the non-compliance has come back and it is still not done.
No, I was in the middle of doing it. I'm going to throw it over to Joni now.
Thank you. So I would point out that a few things. So we do continue discussions with our partners, and those partners do include the parties to the Canadian Human Rights Tribunal orders. We are funding actual costs for prevention for First Nation agencies, as an example. The deputy mentioned that we have doubled the funding in this area. That's a huge investment that is going directly to
Okay, thank
agencies.
you. I'll leave it at that, Georgina, if you'd like to ask a question.
I do want to say one thing. Principally, this language that the government is using sounds very, very good. And because of that, it sounds like I'm open to supporting it. However, having said that, this bill is quite flawed, and I'm very disappointed as an Indigenous woman who goes into the riding and sees the reality on the ground for First Nations and Métis children on reserve and off reserve. The investments required for the moms and the dads to stay at home and to get the help they need from healthcare, from health and healing programs, from training programs, and a job, the investments there. And then the social workers and the physicians and the nurses, those that provide all the medical care, including the RCMP, who often get called, get involved because there are no social workers available. Without these investments, how can we say that the child is the center of this? I think that is misinformation that the government is talking about. I'm supportive, child first. I'm supportive of their well-being. I'm supportive they have family to love and support them, and families have the support they need. Why is the government misleading people and have no funding attached to this bill?
This is a bill that deals with jurisdictions, not funding. It is a deal with it deals with jurisdictions in a way that has never happened before. In a groundbreaking way that has never happened before.
I don't understand when you said
where national organizations,
I don't understand that
such
piece.
as the IWK and the Métis National Council and the Assembly of First Nations, have worked with us. We followed their lead.
With all due respect, the agencies, the national agencies, I'm not disputing their support and the work that they've done. I fully support the work that they've done. But on the ground, they don't have influence over on the ground when a child and the mom or the dad or the grandma or the grandpa or the aunts and the uncles, cousins to take care of them. I understand that concept, but I think the government is missing the point. And yes, you are, because you don't know the realities on the ground. When you see the child, there's no funding available attached for the mom to go to treatment, for the mom to apply for training, for the mom to want work, or dad.
It is
and
not.
There's no
Georgina,
funding.
with all due respect.
No, with all due
no,
respect, you don't understand. Don't condescend to reality on
I'm
the
not
ground.
condescending to you.
Yes, you are.
Well, I would wish
It's
that everybody
insulting.
at this table would stop condescending to them.
No.
To them.
You're missing the point.
No,
because when I
I'm not
look
missing
at the
the
ground,
point. I'm not missing the point.
Yes, you are.
No,
Put this
the
down.
nations and the bands themselves will determine that on their own. They will determine it on their own.
So when it comes
Separate
to
from me,
investments,
separate from you, separate from everybody at this table.
investments to the parent, the family that they need, the investments. How can the government assist with that process?
That is exactly at the point that we wish to be at should this bill pass.
We've run out of time on this round. We're going to, for the opposition, we're moving to the Liberal team, and I see that next we have MP Mike Bosio.
And I'll be sharing my time with MP Falcon Ouellette. I just, last night I hosted an event, the screening of a documentary on an individual, Eddie Goff, who was a child, an Indigenous child taken from his family and raised by another family, and the trauma that this had on his life. But thankfully, the journey took him back to his original family roots on Manitoulin Island, and where he has reconnected with family, with his culture, and so thankfully it's a happy ending to what has been too often a very tragic story to too many Indigenous youth in this country, children in this country. Can you help us understand how this legislation is going to hopefully put an end to the Eddie Goffs of Canada, so that they will continue to benefit, so they will grow up in their family settings, in their culture, with their language in the future?
I don't want to presume what that system will look like, because that would, I don't want to make any patronizing assumptions of how this will go. What we agreed upon were three, I think, fairly good principles with them. I mean, the first, of course, being that for the child, the rights of the child is first and foremost. Secondly, that and this is a very important point, that the traditions, the culture, the language of an Indigenous child is essential to their health. Essential to their health. And thirdly, that when dealing with the system, the child and the family caring for that child should always be dealt with with dignity. For those of you who have had fairly good treatment when you've dealt with hospitals, those may seem like fairly basic things. It is not to a lot of people who will be affected by this legislation. So each one of them needs time to work through it. Those who determine that, we're ready, we'd like to take this on now, we've waited long enough. And last week I had dinner with a group of Cree women and elders just outside of Winnipeg who did not want to involve the province whatsoever. Let's get it done now. And we had to convince them that, some work needed to be done. But the bottom line is this: they have a year to enter into negotiations with the federal government and the provincial government to help them build their own child and family services. Now, a lot of that is based on making sure that they have that a kid has access to all the right things, to the things that they know, their extended family, that in the eyes of the law they're legitimized, not that they need it, but that they're there and that they're empowered, and that communities get to develop their own way of dealing with situations, of dealing with children in care.
Now is going to
And
be
I
Robert
would
Ouellet.
simply add, just finalize this, if after 12 months these coordination agreements are not dealt with in good faith, then the legislation that has been developed by the Indigenous groups supersedes provincial and federal law.
So that actually, it's a very good segue. I'd like to thank the Minister for coming. When I started out here in Parliament, my maiden speech was actually on child welfare. And actually, the stats are actually startling in Manitoba. 87% of children who are taken because of neglect or issues surrounding poverty. That means only 13% have actual allegations of abuse. And of that, only 12% have substantiated abuse in the province of Manitoba. So most children are not taken because of actual abuse. It's because there are major problems in how the system's dealing with poverty. And I hope this starts a process in order to actually start dealing with that problem, those 11,000 kids in care. Now, we talk about the laws. How are we going to determine when a law has been passed by an Indigenous community? And what constitutes an Indigenous community? What constitutes an Indigenous nation? Maybe that's for the Justice Department. How are you going to determine that is a nation?
So in the legislation, there is a section that talks about the duty of the minister to publish the law. So it will, once the law comes into effect, it will be the title of the law, the text of the law, and the date of coming into force of the law will be published on the department's website, and it will also be published in the Gazette. So that will give public notice that a law has come into force.
So, in relation, for instance, to the Métis, would the Métis National Council in BC, Alberta, Manitoba, Saskatchewan, Ontario pass some form of legislation, and then how would that become a law? And then would the federal government then take that law and publish it in the Gazette?
So it's Section 35 rights bear holders that will be able to develop such laws. And as the minister has explained, there is a process of making a request to have a conversation with either the province or the territory in which the community is located in. And then after 12 months of negotiations, the law would come into effect. And then we would have the publishing tools that I just mentioned to you.
So if, like, for instance, like Treaty 2 territories, an example, decided to come together, would they have to pass it under the Indian Act under bylaws?
No.
Or would...
No, it's under this framework. So this framework, this legislation creates the framework under which Indigenous groups, bodies recognized under Section 35 could develop their laws and then have it published and implement their laws.
So how would you... I guess my question is, how do you determine that that's a constituted group? And
so in the definition section, it talks about what is an Indigenous body that can do so. And there's a specific words that says authorize. So the Indigenous governing body means a council, government, or other entity that is authorized to act on behalf of an Indigenous group, community, or people that holds right recognized and affirmed by Section 35 of the Constitution Act 1982. So there are different mechanisms to be authorized. Some First Nations may decide that resolution would serve as the purpose to provide proof that the body coming to negotiate is authorized on behalf of either, it can be a community or it can be a group of communities. And then if you have a group of communities coming, in your example, under Treaty 2, then perhaps each community would have a bylaw or would have a mechanism that speaks to the fact that it authorizes the body to engage with the provincial or territorial government to speak about the implementation of the law that group would have developed.
so as an example, like...
I've allowed a minute and a half over.
Oh,
so we need
this is actually
to...
the crux of the issue that we're...
I'm sure that we're going to continue this discussion. We're moving over to MP Kevin Waugh.
Thank you, Madam Chair. Thank you, Minister and departmental staff. Ms. Wilkinson, do we have a legal opinion on this constitutionality that we're just
I'll
talking
ask
about?
our colleague from the
Okay,
Department
Ms.
of Justice
Sargent.
to speak
Yeah.
to that. Thank you.
I think that's the question everybody in this room wants to know.
Sure. And I can say that, as always, Justice has, of course, been working very closely with our colleagues in Indigenous Services Canada in relation to this bill. And also, as always, we are not going to be necessarily in a position to share the legal advice, but I'm very happy to provide a bit of an outline of some of the relevant case law, if you'd wish. But the bottom line is that, as Deputy Minister Tremblay said, the position of the Government of Canada is that this is a valid exercise of federal jurisdiction under Section 9124 of the Constitution Act, which, of course, uses the old language of Indians and land reserved for Indians. But this legislation is intended, of course, to deal with Indigenous children and to address the needs and support Indigenous children, communities, and families in the exercise of their Section 35 rights. So there is a constitutional basis for the legislation. I will acknowledge that, of course, provinces and territories under their jurisdiction, Section 9213 of the Constitution Act, have long been exercising jurisdiction in this area. So it's, in a way, best viewed, this legislation, as a federal overlay a double aspect, to use a constitutional law term, that is very much intended to support the exercise of Indigenous jurisdiction in this area.
Okay, we have more time with you throughout the morning. Mr. Minister, it's interesting. I like our Shadow Minister agree. I thought this was interesting. The amount of children in Saskatchewan that are in care today is higher than the residential school system. That speaks lots. I know the provincial government in Saskatchewan feels left out. You were in Saskatoon last week. You did not meet with the minister, or you wanted the minister in the same room as the FSIN officials. You know, and I think when you bring the federal aspect into the provincial aspect, I'm wondering why you wouldn't meet with Paul Merriman, the social services minister, one-on-one, when he asked you last week for a meeting and you turned him down.
Mm-hmm.
Why is that?
I turned him down because he wanted to talk about the legislation. And the legislation.
Well, shouldn't he?
Yeah, I know, and I'd very much like to talk to him about the legislation. I'd like to talk to him about the legislation with our co-development partners. I'd like to talk to him about the legislation with the Assembly of First Nations leadership that were present, with the IWK leadership that was present, and with the MNC leadership that was present.
Yeah.
There are three fine people who were present for some of the meetings.
Yeah.
We were as accommodating as possible. He did not want me in the official meeting because he didn't want them in the official meeting. So we tacked on an extra day, and so it was a good opportunity then for us to discuss it.
But I can see the reservations right now from the provinces of Manitoba and Saskatchewan because you wouldn't meet with them. I mean, they have been in charge of this. They may have some issues that they want to share confidentially with you. And you, as the minister, should take the time to meet with a provincial head. And I'm very disappointed you didn't do that. I mean, if you're going to do the consultations, start with the right holders right now, the province of Saskatchewan, which you didn't do. And why are you not doing that?
And I'm very disappointed that they wouldn't meet with me rightfully. I'll be blunt. This is what reconciliation looks like. They wrote it with me.
Well, I know this legislation was partially written by the FSIN. I know that for a fact.
Mm-hmm.
I'm true on that. But now you've caused an issue in my province of Saskatchewan.
I have.
Yeah, and are you happy with that?
No, I'm not content with it, but there it is.
So what are you going to do about it?
Continue negotiating.
But you're not.
With the provinces that certainly want to.
Oh, so because there's nobody, if Paul Merriman wanted a meeting personally with you, you want other people in the room, you would not have a one-on-one meeting with him.
I'll take his phone call anytime he calls me.
But you didn't last week?
I spoke with him on several occasions last week.
So you see where I'm coming. This is a bill that is coming.
I mean, you can see where I'm coming from.
Yeah,
I flew in from Saskatoon. I went to a meeting a day early because they didn't want to have me on the official meeting. So I went to the unofficial meeting. Then they refused to put me on the minutes as having existed at the meeting. Nor did they want to put on the minutes the existence of the three other organizations that were with me. Look, I don't take anything too personally by all this. This is all the kind of games that we play in the short term. In the long term, do I think that we'll get there? Yeah, I do believe that we'll get there. And I think that all provinces will come on side because it just makes too much sense. All of this does make too much sense. There'll be games played. That's fine.
There is games played, and I right now people are getting hurt by it.
The 5 minutes is up, and we're moving back to the Liberals. And who is taking? I'm looking for an indication. MP Will Amos.
Merci, Madame la Présidente. J'aimerais poser une question.
I would like to ask a question about the reaction of the province of Quebec about this bill. For people in my riding of Pontiac, we've had a number of disturbing cases where Indigenous children and the services for families. In the Gatineau Valley and in our region, we've had a lot of big problems with this. The future of these children and their families and their communities is at stake. So I would like to know what the Quebec government's reaction has been to this new legislation. Of course, the problems that we have seen have been in the recent past, but before this government or the current government in Quebec was elected. So what is the new government's reaction? During the consultation period, when we held meetings face-to-face with the provinces and territories, all of them backed the principle underlying this legislation. The province of Quebec and some other provinces mentioned the fact that it may take some time to prepare for implementation of some of the clauses in the bill. So they did raise the fact that even though they supported the principles behind the bill, there might have to be a period of time during which training would have to be given to frontline workers and so that the services could be provided under the bill. Thank you for that answer. Has the new Quebec government raised any constitutional or jurisdictional issues besides the time that would be required to implement legislation, as would be the case with any really new approach that is so crucial for communities and Indigenous children? They didn't raise concerns at the meeting as such, but they said that they hadn't had the time to do a full analysis of jurisdictional issues and constitutional ones, and that they would come back. But at the meeting, they did not raise any particular concerns in those areas. Thank you. Thank you for those answers. It's very interesting. I really appreciate it. And especially in the Gatineau Valley, we've got the community of Agapit, Algonquin communities. They are very much affected by these issues, and I know that they have reacted very favorably. So if you could give me any other comments, well, not just the Algonquin communities, but there are other very positive examples in Quebec. Others have talked about the positive experience they've had with these, the new approach at Atikamekw. So they have certainly had a positive experience. And this bill does not call into question things that are already working. It just provides a more positive approach. So you are quite positive about the relationship between the provincial and federal government on these issues. Where Quebec is concerned, it's not the same situation as we're hearing about with other provinces and other sectors. I think it's been positive with all of the provinces and territories. Thank you. I'm glad to hear that.
Arnold Viersen.
Thank you, Madam Chair, and thank you to the Minister for being here today. One of the things that's surprising to me, I guess, is that we do seem to have the provincial minister in Saskatchewan seems surprised by this. We have a bunch of jurisdictional issues around who is the Indigenous governing body I know in Alberta, we have the Métis Nation of Alberta, but then we also have the Métis Settlements of Alberta. Who is going to stake claim, I suppose, on these children? And the very fact that we're sitting here months away from the summer break and in the last year of this Parliament, that so I could see.
Sorry.
Yeah.
I'm going to ask you to be really quick because our clock is wrong, and I didn't realize that we're actually over. So one short question
Okay.
I'll give you, and then we have to call it quits.
Yeah, so basically, I guess I'm surprised that we don't have the jurisdictional issue between, like, say, Métis Nation and the Métis settlements in Alberta necessarily sorted out. We don't have, Saskatchewan doesn't seem to be overly excited about this legislation, and we are where we are at. What's the likelihood of this piece of legislation passing into law? And what's the likelihood of there being a court challenge to this piece of legislation if it is passed into law?
Well, just at the beginning of your question, I just counted back 22 engagements with provinces and territories in the summer fall of 2018 on options for potential federal Indigenous Child and Family Services legislation. And 22 at senior level, deputy minister level, assistant deputy minister
Which could
level.
explain why we're here today. But it would,
One question.
It would also, I would expect at this point there wouldn't be any, if we're here today because of all those meetings, I would expect that those issues would have been ironed out by now. And it doesn't
Final
seem
word to the minister, then we need to let you go.
Can you explain that to me?
Well, I mean, regardless, we'd be here, no matter how well those meetings went or how poorly.
Then how come?
Very good. We're actually over time, so I'm sorry for interrupting, but I've already exceeded our allotted time, so I apologize to everyone who is waiting to move. Thank you so much for coming out. We have begun the exploration of the bill, one of the most important pieces of legislation in Canada. Thank you, Mr. Minister, for coming out. Really appreciate it. Merci, Megwitch. Damn. Because we do have officials that are remaining with us, and now we can dive right into the bill. So, going to ask everyone to come back to your seats, and let's continue exploring Bill C-92, an act respecting First Nations, Inuit, Métis children, youth, and families.
Do you want to restart the rounds of questions?
Yes, I'll restart the round. And after we have Are we going to, are you expecting to do another presentation or all questions? All questions. So we're going to begin with the Liberal side for a 7-minute round. And who's taking the lead? MP Robert Falcon-Ouellette is going to lead us off.
So I'd actually like to discuss Clause 9.3e, and that's about concerning the Jordan's Principle. Is it acceptable? Excellent. So Clause 9.3e states that in order to promote substantive equality between Indigenous children and other children, a jurisdictional dispute must not result in a gap in the child and family services that are provided in relation to Indigenous children. Now, the concept relating to jurisdictional disputes reflects the Truth and Reconciliation's calls to Action 3 that all levels of government fully implement Jordan's Principle. Now, I guess, we have been implementing a lot of that, more funding, $1.2 billion for Jordan's Principle. But have you had any discussions surrounding funding concerning this into the future with Indigenous groups, and why this clause is in this bill and why it's so important?
Answer on the questions on why is it in the bill, because you were part of the engagement session.
Correct.
Okay for you. Yep.
So this section, and there's a couple of others that touches upon the Jordan Principle, were specifically included in this bill at the request of participants in the engagement session. And while we did not specifically call it Jordan's Principle, the principle behind the Jordan Principle is what is captured in the section that you're referring to. And the purpose of not calling it or identifying it Jordan Principle is because this bill is much broader than Jordan Principle. But we wanted to make sure sorry, and especially in this section, that the concept of not having a gap of services applies in the context of child and family services. So that's why this section was particularly added here.
So as we implement, let's say in 2 years' time, we have an Indigenous group, Treaty 4 territory, Treaty 1 territory that says, we pass this legislation, the communities then create their own regulations about how they want to implement that, and then they decide this is the types of services we believe our children require. How do they go about then obtaining the funding to ensure that there is no gap in service and that they're actually able to accomplish the desires of the community to, look after their children and see their children mainly succeed and reach their full potential?
It's the discussion we're going to have with them. You mentioned the Daughters on Jordan Principle. As you know, we have more than 200,000 cases of Jordan Principle that were addressed, and probably a budget that is over $400 million per year now on Jordan Principle side. What is important in a case like you mentioned is looking at the resources that are there, and exactly after that, identifying what are the needs, what kind of services, what kind of jurisdictions, and how do they want to exercise their jurisdiction. At that point, if there's a gap between the funding available and the funding needed, that's going to be a discussion between government that would be an important one. The bill at the moment, as it was mentioned, doesn't necessarily address those case-by-case issue, but it is something that will be part of the discussion in each case. We don't expect that it's going to be the same everywhere, so we have to take that into account too.
One of the issues that I believe that is faced in Manitoba is there was a devolution of authority, administrative powers to Indigenous communities with the Northern and Southern Authority, who supposedly technically have control. But over time, what happened is the province just created more and more regulations layering on due to, I suspect, political fears of children being hurt, being killed in care, and there are over 400 children actually have been killed in care under the responsibility of the province in the last 8 years, or some terrible statistics. What is the guarantee that the federal government will not start layering on more and more regulations and trying to direct First Nations in how they carry out what they deem their responsibilities are in relations to looking after their children?
Yeah, You're right to point it out. I mean, this is a discussion we have had with First Nation leaders in Manitoba. The way it was described to me sometime was that we included First Nation in the system. We didn't change the system in Manitoba, and the system continued as it is. And as you said, was reinforced by some cases, and that actually kind of created incentive for more apprehension of kids. What we think is different here is look at the principles that are there, and it's also the recognition of the jurisdiction. First Nation, Inuit, and Métis have a jurisdiction recognized, and they can exercise it. And if there's a bad faith from more part of the provincial government, they can actually, through the process, go ahead with their own legislation. So this is a very significant change. And the principles that are there, cultural continuity, for example, as well as substantive equality that we talked about, and the best interest of the child, we hope would be guaranteed to make sure that what we're doing here is opening the door for a system to change, not actually reinforcing a system as it is.
Another question is, how difficult was it to obtain agreement among so many different Indigenous communities? One, we're talking about Métis, Inuit, and First Nations, who are also very, very, very diverse. We call it distinctions based. The idea that we're all different and we have our own distinctions. How difficult was it actually to obtain agreement? Because usually when we deal with bills in Parliament, usually they're very much more restrained in dealing with either one group or another group. Often it's either the Micmac educational laws or the BC Tri-Part agreements or the Dakota self-government agreement, very restrained. How difficult was it actually to obtain agreement surrounding this?
I think we try to focus on where there was a consensus among the parties. And there was a consensus that measures needed to be taken to make sure that the kids were not taken the way they are taking in some places as it is now. And that was an important element that was coming from all across the country that we heard from everybody. The other element was the recognition of the jurisdiction. That was another element. So rather than having a legislation that tries, which is not necessarily something bad, but in some system and what First Nation, Inuit, and Métis would likely do in the future, which is to describe what they want, this legislation doesn't go in that kind of level of detail. This legislation opened the door for First Nations, Inuit, and Métis to occupy that space. So that was the way to get consensus as much as possible among the parties, was to not predetermine, as the minister said before, what exactly the solution looked like, but to set the stage for actually those discussions to happen. This bill actually opened the door for the beginning of a discussion, and that discussion would happen at the national, at the nation's level, at the regional level, at the local level, way more than downtown Ottawa, if I could say. With all due respect, with
this is
other
good. Thank you very much for being concise. I was just wondering how this bill, C-92, would implement or reach in some concordance or agreement with UNDRIP, or the UN Declaration of the Rights of Indigenous Peoples, and its implementation. How that would is that reflected in this bill?
Is it the preamble, as far as I remember?
So UNDRIP is much broader than this legislation, and maybe you're raising this because it was mentioned in Bill C-91, but in C-91, UNDRIP is particularly refers to languages, whereas UNDRIP does not particularly make a reference to child and families. So that's why it's not specifically mentioned in this legislation.
1 minute left.
Laurie?
Yeah, go.
Yes, just wanted to clarify. So it is in the preamble, of course, of this bill as an overarching commitment to implement and, implementing the UN Declaration. And just to sort of nuance that response, the Declaration itself, it's true, doesn't speak specifically to child and family services. There are, of course, many provisions that relate to children and families generally, and the principle of self-determination, which is very much underpinning, I would say, this legislation. But as Isa pointed out, there's not quite the same level of specificity as in relation to language.
When you say self-determination, what do you mean for the average Canadian? What does that exactly mean in this legislation, and why is it important?
Sure.
Very short, clear definition.
It's the power of a group to decide their own faith and their own path.
And that's in the legislation.
Okay. We're moving
Just
on
getting it on the
to MP Kathy McLeod.
Thank you, Madam Chair. And I think I want to pick up where we were going earlier with Ms. Sargent. And would you, first of all, I'd like to ask you, talked about different case law. So if you could table that case law with the committee, that would be very helpful. And so as I understand, the sort of, you're using section, 9124. And it, of course, is a little bit not totally defined. And what I perceive is that this legislation is defining the authority. Is that accurate?
Well, I mean, this legislation certainly recognizes an area of jurisdiction in relation to Indigenous governments, essentially governing bodies, which is a Section 35 Aboriginal rights framed piece. The legislation itself, I would say, is founded on 9124 as a basis for federal jurisdiction in this area.
Okay. So the Section 35 rights, typically it has been defined in many cases through court cases. Can you also table with this committee the legislation that has been created by parliaments that have defined Section 35 rights as opposed to a legal process that has done that definition? Has that happened frequently, and can you clarify that piece?
So this is novel. I will say that this and the Indigenous Languages Act are probably the first two instances where Parliament has decided to speak to the recognition of Indigenous rights, Section 35 rights, and it does flow from the approach that this government has taken in relation to a recognition of rights without awaiting judicial decision making. So in relation to case law and so on, I'm happy to table a couple of different decisions, but ultimately there is no decision that's directly on point. One resource that I can point you to that I think would be of great use is an article by the Honourable Justice Sébastien Gramont that was published in 2018 in the National Journal of Law and Social Policy. It's readily available online, but I'm happy to table it as well or through the Department of Indigenous Services, because it actually gives an excellent overview of both existing law, provincial basis for legislation in this area, but speaks to both the 9124 and the Section 35 aspect. So it's an excellent compilation, better than just reading the individual cases.
Thank you, and that would be really appreciated, and I think would be very helpful. Mr. Tremblay, it's interesting as I go through this legislation, and I did sort of talk about that prenatal issue when, delivery of prenatal services is clearly provincial jurisdiction. One of the gaps is this is absolutely silent on people as they age out. And we know that there is significant challenges, and I would have thought it might have been more appropriate to have that identified and be a part of this legislation than perhaps the section that I just talked about. Because we know that our youth, and I guess I still consider, I used to think 18 was an adult, but as the older I get, but what
a different point of view. I know the feeling.
But we know there's a real gap, and we know that 18-year-old, 19-year-olds end up with huge challenges. Mm-hmm. So why are you completely silent in that area in this legislation?
First, I want to say that this legislation is not the legislation that fixes everything. It's a legislation that is actually part of a general process of reforming child family services and addressing the needs of First Nation, Inuit, and Métis. So it's not the only thing we're doing. What we're doing with the legislation is what the legislation is so good to, is to put the legal framework. And the legal framework is to say what it says. I will come to your point. And including the recognition of jurisdiction that could not have been done without that legislation from our own point
But
of
you
view.
delve into prenatal, but you don't go into
We
older.
are looking at all those areas, but we also believe that a lot of those issues will be better addressed in a discussion with the right holders and the First Nation, Inuit, and Métis. There's no one size fits all across the country on what should be an approach on child family services. So it will be an interesting Babel Tower, if I could say, if we were trying to actually just summarize this in one bill. The best for this is to actually, as I mentioned before, is to create the framework in place that those discussions can happen. But it's not the end of a process. It's a beginning of a process. It's a journey that we're starting. So that those questions are the right questions, but they are questions that the legislation could not answer from Ottawa. It's going to have to be through the processes.
So I can think of a delivery organization in British Columbia who has a delegated function, and they take on both on reserve and off reserve in terms of the work that they do. So, there's been the agreement was signed many years ago. So technically, what's going to happen to them in terms of what is the evolution of their next step? Because they've already drawn down on and off reserve. And so what difference is this bill going to make to them?
The difference would be more the discussion. If they're doing a great job and the First Nations who's working with them say they're doing a great job, I don't expect there would be a lot of changes. Exercising jurisdiction doesn't mean that you're going to pass a law tomorrow. If you look at a lot of the First Nations who are under self-government, they have jurisdictions on education, health, and many areas. They don't necessarily pass law on all those issues. In many aspects, they take part of the legislation or the rules that are already put in place by provinces. I think it's going to be the same case here. You've got to have First Nation, Inuit, and Métis questioning what is the best for their children. And in some cases, they will work with agencies that
This
they like.
is a First Nations-led organization.
Yeah, okay. In this case, if the First Nation-led organization is well perceived by the First Nation themselves, I don't think they're necessarily going to change it. So it is not necessarily there to replace good practices. It's there to help the ones who wants to do something different to have the tools to do it.
Thank you. So when this First Nations-led organization has made, in rare occasions, the very difficult decision that it is in the best interest of a child to have other alternate care, is it just the minister, or does the department call this abductions?
No, the minister referred to cases that were mentioned, that when it's only for socioeconomic conditions, cases that what we call sometimes in Manitoba birth alert, or kids that are apprehended at the birth, and they are not necessarily there was not necessarily work that was done. And sometimes, as we heard from First Nation, and the minister heard it, and we heard it from the Métis too, and the Inuit too. They were takings in some cases just on the profile of the mother, on what she was in the past, not what she is at the moment. So that's what they refer to. When you talk with First Nation, Inuit, and Métis, they all recognize that there's a moment where protection is needed. Nobody is against protection of children here, and that's why the interest of the children is so important. The question is, protection should happen only when other methods and tools have been used before.
Good. Questioning now moves to MP Rachel Blaney.
Thank you. Thank you so much for being here with us today. So I just wanted to ask a couple of questions. When the minister was here with us, he said a few things that I just wanted to get clarification on, if you could talk about. He said it's up to Indigenous communities to tailor to their needs. And also he spoke about doing that work based on the capabilities of the community. So I represent a large riding in British Columbia with many Indigenous communities that are very, very small. So when we talk about capacity to do this work, some of them have that capacity, some of them are limited. I'm just curious if the basic capability of the nation will, in this legislation, make it so that they can't take this next step.
If you referred, you know it as much as I do, and probably more. BC is a good example of communities decided to join together sometime to take jurisdictions or to take control of their own business.
So in my writing, there was an attempt to do that, and they were denied the ability to do that because they were still within those small communities together, not considered large enough to do
Okay,
that.
but-
So I just
Yeah.
want to make sure that when this bill comes into place, because it's a government bill, of course, that those things are going to be represented in this.
There is, if capacity is issues are linked to many reasons. Being a small community is one of them. It's not the only one, but it could be also sometime other issues that they will face. The issue of capacity will have to be addressed. If you're really a small community, it may be difficult to manage an overall system. It doesn't mean that you should not be part of a jurisdiction or a way to manage it. For example, when I was talking about the self-government nations, a lot of them didn't take or decided not to go with the legislation because they thought that there was not necessarily the economies of scales to manage a health system, for example. That's why in BC you've got a First Nation Health Authority, as you know, that actually deliver health services to all First Nations across the province. So in a case like that, it's difficult to make an assumptions on case by case, but it's not to exclude any size of the community. That's not the point. They all have the same rights and they all need to be respected the same way. But from a practical perspective, that's the kind of discussion they're going to have, which is what do they need to actually, what are the means they need for their ambition, to meet their level of ambition. And in some cases, it may mean for them to work with others if they find that it's actually the best way for them to get the capacity for this.
So one of the things is Indigenous communities are really being asked to rely on the spirit of this bill to make sure that there are actually going to be the resources available for them to do the work. And we know that in the budget, the 2018-2019 budget, there's $0 for any sort of implementation of this. So I'm just wondering, how do I ask Indigenous communities across this country to have
believe me.
faith?
Yeah. The bill is doing something that is very innovative, as it was mentioned. The fact that we recognize jurisdiction the way we're doing in this legislation was not done in the past. So this is something quite exceptional. We haven't waited for this bill to engage with First Nation, Inuit, and Métis on child family services. As it was mentioned, there was the extraordinary meeting in January 2018. And even on the funding side, we have almost doubled the budget for the existing system. But it was also mentioned in the discussion at CHRT that the system needed to be reformed, and that's part of the reform. And and even if even now, today, if you go on the self-government side, there is negotiation across the country. And because we have actually put the emphasis over the last few years, the emphasis has been put on child family services, more and more of the First Nations or the Indigenous groups that are negotiating self-government are focusing on child family services, and those negotiations are resourced. So we're not without any resource at the moment. We are doing things, and we are investing more in the system.
So if an Indigenous community right now came to that table and said, okay, we want to add this into the negotiation process, that's something that the government would not only support, but actually have some resources
Under
for.
self-government at the moment, there's actually a significant numbers of them, and yeah.
Okay, so one of the other questions I have is why was the word apprehension used? That language is pretty outdated. Currently, the more often used is child removal and placement in alternative care. So I'm just wondering, why was that language
I don't know, my English is so bad, I would let her decide on why apprehension versus other terms.
So the question was raised, and it's basically to be consistent with existing language used in other legislation. So the apprehension language is now being used, and to make sure that our legislation was consistent with the language being used across, we use that language in this bill.
Okay. So one of the other things that I noticed is that the bill doesn't really address the need for technical or data collection. And, there are some communities that have some capacity Some have very low capacity. And I'm just concerned about making sure that that support is there pre and post. I think that's also important, that pre part of making sure that there's the technical support in terms of, building this internalized legislation. Like, they need the support and then the data collection as well. So I'm just wondering why that wasn't included at all.
As I mentioned before, this legislation is part of a general plan. There were 6 points. One of those 6 point, part of the 6-point plan is actually data, and we're working with the partners, but also with provinces and territories, because there would be a significant impact on them for this. It's a discussion we need to have with them. So those issues are being discussed and addressed. They're not in the legislation because, as I mentioned before, the legislation focused on what we thought the legislation was the best to address, and where there was a significant consensus that seemed to emerge, and it is about the jurisdiction, and it is about the protection of the Indigenous people in the existing system. So that's part of the general reform. It's a legislation that is actually one tool that we have to address part of the puzzle, if you want, not to address everything. But it is something we recognize that will be a challenge and will need to be addressed for sure.
Okay. That ends our round for MP Blaney, and we move to MP Yves Robillard.
Alors, de nombreux enfants sont actuellement.
So many children are currently in care, but not provided by Aboriginal bodies. How will this legislation affect them? Do you want to start? Yes, I'll start. So in the bill, there's a section which addresses that type of situation. And I think it's under 16, section 16. And what's required is a regular reassessment of each case. Now, as part of that process, we encourage the unification of children with their own families. So in the bill, we ensure that children who are in care currently, that there's a regular assessment that takes place to make sure that when it's in the best interest of the children, they can go back to their original families. The Manitoba Chiefs Assembly has said
perhaps if we could keep an eye on it and give us 10 minutes to get to the House.
I think we can go 20 minutes. Yeah, I think that's fair. We're here in the House, right? So in the building.
Which is why we're here.
Yeah, exactly.
Yes.
So it's perfect.
MP Ouellette?
So I noticed in the schedule that we're from 12:30 to 1:30 still to determine.
I'm sorry that we have tried to condense the day, but this has not been successful. I'll take this opportunity to inform the committee that we need to stay for the final window because one of our delegations is not able to move up to 11:30, so we will be in committee until 1:30 p.m. So please note that in your schedules, and there has not been possible. We thought we could.
Is it possible to make sure that these officials, because I think this is the most technical part, which is quite important, perhaps stay a little bit longer if we break for our vote, because this is, there are very important questions, and if we only have one group, they can have a chance to speak at length on an issue, but.
Well, they could come back at 12:30. No. What? No. We will try to be as efficient as possible. Ms. McLeod?
So the motion is we have bells.
Stay.
Unanimous consent to stay till 10 minutes. And I think out of respect for the other blockings, we continue and give them as much time as possible.
Yes. So we will stay. Do we know what time? We have 28 minutes before the vote, so we can stay for another 18 minutes.
We're in the same building.
Yeah, exactly.
All right, très bien. We're all good?
Can
Okay, where are we now? We're Monsieur Robillard.
I'll start back. L'Assemblée des chefs.
The Assembly of Manitoba Chiefs says that this legislation represents the status quo and leaves the control of the system in the hands of the provinces. What's your take on this? And how would this bill support them? Answer. Well, this isn't something that we agree with. This isn't the way the legislation was drafted. It's not what the First Nations in other regions understand either. I understand there are concerns in Manitoba, especially if you look at the history of Manitoba over the past 10 years. There's been a desire to devolve services in Manitoba during that time, but it didn't necessarily work. And now in the legislation, there are parts of it which responded to the concerns of the Assembly of Manitoba Chiefs. Now, this legislation allows the Aboriginals to move forward on reform. The standards that are set out in the legislation will only exist if Aboriginal nations do not develop other standards. So if the Manitoba Assembly decides to put forward its own standards, they will be supported, and it gives the Assembly legal support, legal federal support, which they wouldn't have had before. Now, the legislation, unlike what's been done in the past, applies off reserve as well, and that helps First Nations covered by historic treaties. It helps them to develop an approach which covers the whole population, not just those living on reserves. So we're very happy to continue the dialogue with the Manitoba First Nations, but we really think that this legislation is there to support the development of their standards. It's not there to replace the desire for self-determination rather expressed by Manitoba Chiefs.
4 minutes. You want to share your time? I'll take the opportunity if
Sure,
possible.
please go ahead.
Oh my God.
Manitoba, unfortunately, has, I agree 100%, attempted to devolve the authority to agencies. And I, at that time, was involved with the government as a minister. And I think that there was an attempt to do the right thing, and the system failed. Children died, numbers went up, and it's good to hear that there's new models being put forward. And one of the models that I'm very curious to get an update on is the model implemented in Nelson House. So on the Nelson House First Nation, I understand a new model has come in where the children are prioritized and get to stay home, go to school, be in their community when the parents are provided assistance. So perhaps you have an official that can update us and maybe describe what has been implemented, and the fact that you're getting all kinds of accolades from different people who are watching the progress.
Yeah, I will turn to Joanne on this, but I don't want to paint a portrait of the situation that it's only dark. I mean, there is in Manitoba, and I've seen some agencies, for example, who have reduced significantly the kids in care by working with communities and trying to find solutions that are different than the existing system. So there is actually people trying, and the legislation just aim to actually unlock that potential, and the people who will try to do things differently. But that would then.
And I would say Nelson House is a great example. There are many examples across the country where new models are being tried. The example that you're referring to in terms of the children being the ones who stay in the home and the parents are the ones who kind of come in and out of the home itself, that's a model that's being explored in other areas of the country as well. And there is success seen with that model. But I think, as the deputy mentioned, it really points to the fact that this is all about jurisdiction, and the answers lie in communities. They don't lie at this table here. They lie in communities because that community, Nelson House and others, have found solutions that work for them. And that really is the goal here, is to be able to open the door so that communities can have that discussion, that families can engage in identifying what the challenges are, where the gaps are, and how you can look at new models and share that information across nations as well to make sure that people are learning as they go.
Well, that concludes our time. Yeah, for our 7 minutes, we're up, and now we're moving to MP Kevin Waugh.
Thank you, Madam Chair. I still can't believe the minister used the word abduction. With all due respect, Indigenous child welfare workers in this country, the provincial and territorial leaders, they deserve an apology. And I'm just reading a Star Phoenix article from my city of Saskatoon, prevention over apprehension. So I wish the minister would have used that instead of abduction. But so how are we going to prevent some of this? You know, when I looked at the cannabis bill put forward by this government, they did little or no education. When they brought it out, I mean, they never went to any schools, for an example. They had lots of money, but they never went to the core group that I think in that legislation needed to be dealt with. So how are you going to prevent? Where are you going to start? And how much money? And, you know, it's fine, and I agree with some members around this table that, you know, it's fine to talk about AFN and Inuit and the Métis Nation, but this has got to be grassroots. And I really have a lot of issues with this bill because I have seen how this government goes forward with legislation where it doesn't get to the grassroots, and then we've got major problems. And so let's start there, the prevention. How are you, have you thought through the prevention aspect of this?
We don't only work with AFN, MNC, and ITK. We have trilateral table at the regional level. We have discussions with First Nations and Métis and Inuit across the country. So as I mentioned before, this legislation doesn't try, and that answers your question on prevention. I have to resist to the temptation of deciding what should be prevention. It should come from First Nation, Inuit, and Métis. What the legislation is doing is opening this door and creating this place where they would be a discussion about this. Because at the moment we pay actuals. We pay actuals in the system for the First Nation system. We don't necessarily give any levers to First Nations, Inuit and Métis, to decide what kind of system they want. And that's what we want to force now, is to open that dialogue. But it will have to come from the First Nation, Inuit and Métis. If it's only the evolution of a system as the system is, the risk is that we will reproduce what we reproduced before. It's not the problem of the social workers. It's not their fault individually. It's the system that is based like that, and they take into account the rules of the game, and the rules of the game push them to make decisions that are not necessarily, that sometimes are short-term decisions that over long-term have a significant impact on the kids and the families. So what is the magic solution on prevention? I really do believe that actually all the innovative approach on prevention, and it's the same thing on education, at the end of the day, outside of the principles that needs to be there for everybody, it's going to come from the communities and the nations. And the Nelson case is an interesting one because that's a different one. But there's cases I mentioned where it works with the agencies, where actually the communities completely work with the agencies exploring what are the best way to address the needs of the kids and dealing with protection only the last minute or as a last resort. I don't know if you want to mention more.
Sorry, I'll just mention one other thing on implementation. So the minister mentioned this briefly, but we are working with partners to look at distinctions-based governance models in terms of how to transition. So as has been mentioned before, this isn't in many cases something that's going to change overnight in every single community, but the point is to build on the trilateral tables that exist across the country, but have some distinctions-based governance structure that looks at those implementation and transition issues, including things like funding. How do we build from where we are now to get to a new funding methodology? Those types of things are areas that those committees could look at.
Yeah, I thank you for that, because a lot of bands in my province have a resentment towards the FSIN, and this is very FSIN driven. So when I talk to the bands, well, a lot of it is in here. They've had major work on this. So when I talk to a lot of the bands, they're saying, well, that's FSIN. They haven't really, this is us now. Meadow Lake Tribal Council, for an example, is one that they're in kind of disagreement with the FSIN. That's their perspective. here's our perspective. And I don't think we have peeled back the onion, if you want me to say that, to these local groups. And now I see in my province, why I mentioned it to the minister, it's all about jobs. And now social services, they're talking about the jobs that come with this department. Are they going to be let go? What is the issue now with the jobs in the province? Because I do see this as a big issue with Vice Chief David Pratt of the FSIN going after the provincial government. And now in the legislature, if you don't mind me saying, in Regina, it's turned into more about the jobs than what it should be about the children. So, you know, I don't think we've peeled back the onion enough to deal with ground roots.
You can say to those groups is just that the legislation doesn't impose to them a system here, that if they want to develop, and we're not saying that the system in Saskatchewan should be managed by the FSIN or by another organization. We're saying that the right holders have the right to come with a solution to the problem they're facing. So it's for them to actually come with the solutions at the level they want.
We're going to finalize with MP Mike Bosio. You've got a 5-minute window. And
Thank you, Chair. Thank you so much for being here today. Some great testimony and great elaboration on and clarifications on the legislation. I guess I just wanted to point out one thing. I know I was fortunate enough to be involved in one of the consultations on this bill in Toronto, where we had all the chiefs of the province of Ontario. They're being consulted on the bill. So, I mean, I would argue that the grassroots was consulted, and their remarks were taken very seriously in laying out the legislation. And I wanted to ask, earlier on you had mentioned there's $1.2 billion worth of transfers that is happening right now to the provinces for care. From a funding standpoint, would it not, is that not an envelope that as we transition to this other model, instead of those transfers going to the provinces to deal with it, that it would be carved off to deal with the actual communities that are now assuming responsibility for children's services?
It's part of the discussion, and some of the First Nation, Inuit, and Métis mentioned that the current envelope that is growing is also significantly overwhelmingly for protection. So if you reduce protection, can you take that funding to actually do more prevention? Those are discussions, of course, that we will have to have with First Nation, Inuit, and Métis for sure. But as was mentioned by Joanne, we do cover the actuals for the agencies for both protection and prevention. This money is not going to disappear. So the question is funding the system that the First Nation, Inuit, and Métis wants. And I'm not saying that everything in the current system is bad. I'm just saying that the ones who actually experience the system should actually have a word to say on what they want.
You made it very clear the importance of it being Indigenous created, Indigenous driven, Indigenous led, and Indigenous law. And when we talked about the layers of regulations that could be added on top to work against that process, at the end of the day, if I'm reading correctly what your comments have been earlier, is that it's the Indigenous law that will prevail at the end of the day, and therefore the regulatory regime that would be associated with that would take precedence over any federal or provincial regulations.
Yes. We've been told by some First Nation leaders that strong families, strong kids make strong nation. And so it means that it comes from there. It's the heart of their identity, with languages, of course, and few other elements, language and other elements. So in this case, it's part of the decolonization process here. Is how do you make sure that the First Nation, Inuit, and Métis decide how they want to address those solutions. It doesn't mean that the solutions will be dramatically different in some aspect. It means that they will hone those solutions because they will be their solution, and they will be able to do that. This is, as you know, a general objective with this department. I'm used to say to my staff that we should be a species at risk looking for its own extinction, because at the end of the day, the service has to be delivered by the ones who actually need them. Because if you want them to be adapted to the need of the population, they need to be actually with the ones who actually are on the ground. So that's part of this approach.
And to feed from that, the strength of this legislation is the fact that it is a framework.
It is a framework.
That it is not a one size fits all.
We would not,
every part of the country would have a different solution that could be put forward in order to do it.
We would never have been able to have any consensus, including with ourselves, if we would have tried to define what the system should look like. We have past experience of defining what the system looked like, and that's called the Indian Act. That was not the objective. The objective here is to say, if you want to take it over, you can take it. Because it's yours, it's your jurisdiction. The only thing that we put in the legislation is if you don't take it, we want to make sure that kids continue to will be protected in the future in a better way. And if you take it, we want to make sure that there's discussion with other jurisdiction, because we're a federation. We know that interjurisdictional issues exist, and they need to be addressed as much as possible.
Merci beaucoup. We need to suspend. We'll be coming back. We'll probably be back at about 10 to 11, and then we'll start that session. And I want, if members could think about, we'll have to modify our process probably so that we allow a decent time for our presenters and the Q&A portion. MPU led, are you satisfied? Good.
I just wanted a question on the record for on and off reserve and the impacts on children.
You'll have to wait till next time.
For the officials, but maybe they can provide that information.
Perhaps they'd be kind enough to submit something. We would appreciate it. Thank you. We're off to do the vote. Suspended. thank you, everybody. Thank you for your patience. We're sorry we had to be away and didn't start in a timely manner, but we're anxious to get going now. And once again, we're on the unceded territory of the Algonquin people, and we are studying Bill C-92, an act respecting First Nations, Inuit, Métis children, youth, and families. Of course, critically important to all Canadians. And before us, we have Chief Robert Bertrand and Cindy Blackstock representing the Congress of Aboriginal Peoples and First Nations Child and Family Caring Society of Canada. And my note says that, Robert, you start first, but if you changed it up, it's fine with me. One of you goes. Sorry, excuse me, we'll have a shorter time limit, so Ms. McLeod.
Madam Chair, if we could just take 1 minute, we don't want to cut into our witnesses' time to just set out the logistics. I know we have another vote at 11:48, so if we could perhaps go with this panel till 11:40, that would give us 8 minutes to get upstairs, and that would give us...
that concurrence? Yes.
And then we will have to perhaps adjust the final 4 witnesses, and maybe we can come up with a plan while we are hearing from these witnesses here. Thank you.
Yes, and is it still the intention that we provide 10 minutes for each presenter, or is it the will to reduce their presentation time? No. 10 minutes each, and then we can discuss, do we want 5-minute rounds or 7-minute rounds? 5-minute rounds. Okay, we've got a plan. Go ahead.
I only get 7 minutes. I want my 7 minutes.
There's a request.
That's the only time I get. You guys get multiple time. I only get 7 minutes.
I don't say we'll discuss this a little bit later. Okay, go ahead.
Thank you very much, Madam Chair. Good morning, committee members, representative, and guests. I am National Chief Robert Bertrand of the Congress of Aboriginal Peoples, and with me to my right I have Mr. Jim DeVoe, who is the CEO of the Congress, and before that was a worker in the child welfare system for, from what I'm told, about 15 years. So that's why he's sitting beside me. I am pleased to be with you today and wish to acknowledge that we are on the traditional unceded and unsurrendered territory of the Algonquin peoples and their descendants. Thank you for the invitation to appear and present on Bill C-92, an act respecting First Nations, Inuit, and Métis children, youth, and families. We have, at CAP, grave concerns with this legislation as it fails to meet the specific needs of off-reserve and urban Indigenous peoples and further marginalizes our constituency. First of all, I would like to tell you a bit about the Congress of Aboriginal Peoples, or as we call it, CAP. We are a national Indigenous representative organization. For over 48 years, CAP has been advocating for the rights and needs of the off-reserve, status and non-status Indians and Métis people across Canada and the Inuit of Southern Labrador. Our vision that all Indigenous peoples in Canada should experience the highest quality of life through the rebuilding of nations. All Indigenous citizens have the right to be treated with respect, dignity, integrity, and equality. We must keep this vision paramount for our Indigenous children and youth. Today, as mentioned on numerous occasions, over 70% of Indigenous people in this country live off-reserve in urban, rural, and remote areas. We know this is a large part due to the breakdown of Indigenous family through residential schools, child welfare interventions, incarceration, and other forms of institutionalization. The impetus of this legislation came in part from First Nations communities and the tireless advocacy of the First Nations Child and Family Caring Society of Canada. By expanding the purview of this legislation to include off-reserve First Nation, Métis, and Inuit is seeking to address the needs of people who are constituents of the Congress of Aboriginal Peoples. I would now like to outline CAP's position on Bill C-92. Overall, we know the child welfare system in Canada is broken, and this legislation risks replicating some of these failures. We fear the child welfare system in its current form will be forced on Indigenous communities and expect a different result. We need to rebuild the way in which we deliver child welfare programs and services prior to the downloading of the responsibility. This transfer should not be the end of the state's responsibility to our children, families, and communities. We support our people's ability to govern their own child welfare system, and want to ensure that they are supported to address the challenges that come with this. This legislation should not be a way to transfer the burden of intergenerational colonialism back to Indigenous communities. Without proper funding and an awareness of the political, economic, and social context, this legislation cannot permit full Indigenous control. Now, here are CAP's specific concerns with the proposed legislation. Section 9.1 and 10 refers to the concept of the best interest of the child. This concept is deeply rooted in the colonial system and reflects a non-Indigenous understanding of community, family, and the place of an individual in society. We see an inherent tension between the rights of the child as an individual, as defined by the state, and the collective rights of Indigenous peoples. A child is part of an ancestral lineage with complex relations and is the future of the community. We believe that legislation should allow Indigenous communities to determine the definition and limits of the best interest of the child. Clarification is needed on the government's definition of an Indigenous governing body. It is currently defined as a council, government, or other entity that is authorized to act on behalf of an Indigenous group, community, or people that holds rights recognized and affirmed by Section 35 of the Constitution Act of 1982. We request clarification as to whether urban Indigenous organizations and service providers are considered governing bodies. Who invests these organizations with authority, and who will provide services for all Indigenous people in urban settings? Under Section 15, the legislation addresses socio-economic considerations. Children are at risk most often because of colonial policies, systemic discrimination, and intergenerational trauma. Every effort must be made by all levels of government to ensure that communities and families are supported in ensuring the well-being of children prior to intervention, such as the apprehension of children. This legislation should not force the consequences of colonialism onto Indigenous child welfare providers. The government must be required to redress the root causes of the degradation of Indigenous communities and child vulnerability before child welfare services are even considered. Legislation should require the government to provide diversionary services for communities and families. Section 18.1 of the bill establishes the potential for Indigenous governing bodies to have an opportunity to work with provinces to take over jurisdiction. It is not clear what the implications are for the non-status, off-reserve people, and Métis with origins across Canada. For example, for a Métis child living in the Ottawa area, what are the implications if the child and their family are not registered members of the MNC and belong to an urban Indigenous community? Will they be afforded adequate, appropriate, and culturally responsive child and family services? It is also unclear whether jurisdictional challenges will be created between provincial, territorial service providers and Indigenous governing bodies for non-affiliated families, and how will they be addressed? Clear procedural requirements for the referral of off-reserve non-status First Nations, Métis, and Inuit children and families to appropriate Indigenous child welfare agencies should be outlined in this legislation. Lastly, there are no clear obligations for dedicated funding to meet current gaps for off-reserve, non-status, and Métis populations in the bill. A number of funding concerns must be directly addressed with the legislation, such as commitments for Indigenous organizations to develop child welfare legislation, expertise, and resources. Kinship care arrangements, including comprehensive support beyond monthly allowances. Off-reserve resources for First Nations, Métis, and Inuit child and family services providers who are in the process of developing resources within their community, and First Nations, Métis, and Inuit child and family services providers to provide continuous care and services to children and families who relocate, and to maintain continuity of care through supported arrangements with other child and family service providers. We cannot underestimate the degree the child welfare system has negatively impacted CAP's constituency. In closing, I would like to inform you that CAP and our affiliates, our 10 affiliates, were not included in the co-development process of this bill. CAP's exclusion from this process is a critical oversight because the legislation appears to seek to address the needs of the people who are our constituents: off-reserve First Nations, Métis, and Inuits. I am happy to answer any questions you have at this time. Miigwech, merci, thank you very much.
All right, and now we move to our second presenter, Miss Cindy Blackstock.
Thank you, committee members. I offer my recognitions to the unceded territories of the Algonquin peoples as well. And I'd also like to begin by just recognizing Jordan River Anderson, who will be honored on what we call Bear Witness Day on May 10th. And I hope that all parliamentarians will join us in honoring that very special boy who left a legacy that is now beginning to be experienced by many children across Canada. I am not a rights holder, and therefore I will not be offering a position one way or the other to support or not support this bill. But I am a social worker. I'm a licensed social worker. I've been doing social work for over 30 years. And I worked at the Child and Family Caring Society, which is a national First Nations organization that seeks to provide the best expert advice and, in the case of the Canadian Human Rights Tribunal, the resources necessary for First Nations to be able to care for their children in ways they choose. I want to begin by kind of focusing on two elements. One is the funding element that's not in this bill. And I want to argue that it is a false dichotomy to split jurisdiction and funding, that it is a huge mistake to split them. And I'm not going to ask parliamentarians to put in a number in this bill, but I am going to encourage you to enshrine the funding principles that have been found by the Canadian Human Rights Tribunal as a requirement for funding in the bill. The second thing I want to talk about is practice. I want to encourage members to relook at some of the issues on practice, including the word apprehension. It really is a dated word. It is not in the BC legislation, it's not in the Ontario legislation, it's not in the Nova Scotia legislation, and it's certainly not used by those of us who have been practicing in this field for many years. So before I get into that, I'm just going to address a couple of the points from the federal government. The minister was asked about the Spirit Bear Plan, which is to address all inequalities in all public services facing First Nations children and youth and families. and noted that he does not listen to associations or does not consult with associations. And while I respect that position, I just wanted to correct for the record that all the chiefs in Assembly at the Assembly of First Nations have adopted the Spirit Bear Plan in December of 2017. The resolution number is number 92. So this is something that is supported by the rights holders as an important effort to be able to equalize the ability of families to access services. I also want to talk a bit briefly about post-majority care. Post-majority care is not an elective activity. It is a statutory requirement of child welfare systems. And I would say that it's a moral responsibility, too. For children who have grown up in child welfare care, they need that bridging to be into young adulthood with supports for post-secondary education, for training, for mental health services. And so I have been blessed and honored to work with First Nations for about 25 years directly. And I've never heard a First Nation say that post-majority services should not happen. And so I heard the minister and the officials talk about the engagement they've had. And so I'm surprised that there's still some question of whether post-majority services should be included. I support the Youth and Care Network in saying that that should be included. So I just want to move on to my main presentation now. In paragraph 212 of the landmark Canadian Human Rights Tribunal decision that found Canada to be inequitably funding child welfare and Canada's failure to implement Jordan's Principle to be discriminatory, they reference a statement made by then Deputy Minister Michael Wernick, who at the time was the Deputy Minister for INAC in 2012. And he was speaking to an Auditor General's report that found the inequality in First Nations child welfare. And he says something that I think is directly relevant to the funding question. I'm just going to read the short paragraph he says. It says, one of the really important parts of the Auditor General's report is that it shows there are 4 missing conditions. In the previous paragraph, he lists those. It's legislative base, service levels, outcomes the government is trying to achieve, and the funding mechanism. Back to the quote. You could pick any of them, such as legislation without funding, or funding without legislation, and so on. They would have some results, but they would probably, in our view, be temporary. If you want enduring structural changes, it's a combination of these tools. With all due respect, if Parliament wants better results, it has to provide better tools, unquote. Michael Wernick himself, who was then a Privy Councillor for this government until recently, or Privy Council clerk, was tying together the issue of funding and legislation. One is the authority to act on your own self-governing interests for your children. The other enables that interest to be real for children. And I feel that Bill C-92, unamended, as it's presented, places First Nations in a Faustian bargain, where we either take a flawed bill without funding, and maybe the hope of funding, or risk the window of opportunity closing and perhaps being nailed shut. The inherent rights of First Nations and the safety and well-being of First Nations children, youth, and their families ought never be placed in this position. Proper observance of UNDRIP and the Charter of Rights and Freedoms requires more of the federal government. And I think we can all agree that what we want to achieve here is the best for First Nations, Métis, and Inuit children. That mediocre is one of the vestiges of colonialism. I'm not going to spend much on jurisdiction because I know you're going to be calling the Yellowhead Institute, and they've done a good analysis, the 5 leading law professors on that. I would simply say that the Caring Society adopts those positions. We are, of course, in support of First Nations jurisdiction in child welfare, but we do have some concerns about the wording of the bill in that regard. I'm going to move now to funding. The bill, as it's drafted, simply recognizes a call for funding. That's it. It then says in a collaboration section that First Nations should sit down with the federal government and the provinces to negotiate a funding agreement within 1 year. If that agreement is unable to be reached, the First Nations law becomes law. The problem is that you will not be able to enact that law without money. I have spent, along with the Assembly of First Nations, the last 12 years litigating against Canada, trying to get equitable funding for child welfare. We were at the Canadian Human Rights Tribunal last week. We're going to be at the Canadian Human Rights Tribunal next week. And what we're trying to do is get equitable funding for child welfare. We have the strength of now 7, perhaps even 8, legal orders against the Canadian government to try and get to get equitable funding for First Nations child welfare. And so there's little track record there to say that we can hope that these negotiations will be speedy, that they will result in the same kind of equitable gains that the tribunal has set out. What we would like to see is Canada to put in the binding sections of the Act, not just in the preamble, the key principles that the Canadian Human Rights Tribunal has set out as funding requirements. The first one is substantive equality. The tribunal has made clear it's not enough, Canada, to fund First Nations children on a dollar-to-dollar basis with non-Indigenous children, because the hardships of the long-standing inequalities in child welfare funding have created a higher need, along with the multi-generational harms of First Nations kids. So you need to equalize, you need to provide those kids with more money to get the same opportunity. The second one is the needs of the children and families themselves in different communities. You know well, you come from different constituencies, that different First Nations children in different communities will have unique needs, and it should be based on that. The best interest of the child, not from a colonial point of view, but adopting the general comment by the United Nations Committee on the Rights of the Child on the rights of Indigenous children that provides a good framework for interpreting best interests through an Indigenous lens. Taking full account of the child's cultural and linguistic needs, and taking full account of the unique context of the community. Those are basic principles that should be enshrined in Bill C-92. I'd also ask members to seriously consider integrating something along with the Spirit Bear Plan. Absent the Spirit Bear Plan, I think it's going to moot some of the most significant sections of this legislation. Here's why. This bill includes a section on socioeconomic circumstances. It says that you cannot remove any child because of poverty. The problem is that you can't remove a child for poverty today in Canada. It's in none of the child welfare legislations. Poverty isn't a reason for child removal. It is an undercurrent for child removal. And in the United States, in 21 U.S. states and in the District of Columbia, they do recognize the role of poverty in child welfare. They have got statutory language that addresses that. But they go further. It's not enough to say that poverty is an undercurrent in child welfare. They impose positive obligations on the state to remediate that poverty. And if you implement Bill C-92, but you continue to allow the First Nations housing crisis to languish, the underfunding of early childhood programs, underfunding of addictions programs, then some First Nations are going to be able to make some progress, but not the type of progress that really is necessary to be able to enhance and make sure that children are thriving in their environments. The other section that's important is the prenatal section. And I know that that was of interest to Member MacLeod specifically. We absolutely support the importance of prenatal care. But we need to make sure that that's universally available to all family members. And so that's one of the critical pieces. So I understand my time is up, and I am open to any kind of questions.
Very good. Thank you so much. If you're not bilingual and don't understand French, please put in your earpieces, and questioning will open with MP Yves Robillard.
Alors, merci pour... Well, thank you very much for your testimony this morning. My questions will be in French, of course. The first of my questions is for Mr. Robert Bertrand. In the new model for child and family services, would you prefer that funding be prescribed in the bill in advance, or should it be based on the needs of communities, and should it be determined in coordination with federal and provincial governments? Well, it's difficult, I think, to determine the amount you need if you don't know what the needs are, right, first of all. So the second way of doing this, and that would be a more logical way of going about the funding issue, I think. Basically, what we should do is enshrine legislation, but Having said that, and as I mentioned in my introductory remarks, 70% of Aboriginals live off reserve currently. So we have to go out and meet these people and to establish the needs of children in need, if you like. So based on my reading of the legislation, what's really missing, well, some groups have been consulted. This was mentioned earlier this morning, but I can tell you that there's a the broad majority, if you like, of people who have not been consulted at all. So I really believe that these people should be consulted. People living off reserves, they should be consulted, be they First Nations, be they, no matter who they are, they should be consulted. And in doing that, you'd get a better picture of the real issues. I hope I've answered your question. Yes, you have. Thank you. Ms. Blackstock, question for you. The national standards, the minimum standards set out in this bill, do they meet the needs of First Nations, Inuit and Métis children within the child welfare and family welfare system?
Black line version, which I believe members have a copy of, where we have suggested some enhanced wording for the bill. That was something I'd refer to you for our suggestions about how to improve it on that regard. The other important piece, member, I would just call to you is that although I really recognize the positive aspect of cultural continuity, that is only going to be able to take effect if it's partnered with the funding element. So that's really another thing where the funding needs to be there to ensure that cultural continuity takes place, particularly for children who are separated from their families through residential schools, the 60 Scoop, or now through the child welfare system, who are now adults and need to reunify back to their families and themselves back to their community.
Le sénateur Murray Sinclair.
Senator Murray Sinclair called the co-development process to develop this bill was a model based on the recommendations of the Truth and Reconciliation body. Could you talk a bit more about that, do you think?
Share what my experience is that I have seen some of the engagement sessions. I have, at every engagement session I've been at, heard First Nations leadership call for funding for this bill. And it's still not in the language of the bill. So although it's good that government went out and met with people, I think it's really important to understand that even when consistent messages have been given, not just in this engagement section, but in the case of First Nations dating back decades, that sometimes that has not translated into the text of the bill for reasons that we don't understand. So I think that it would be really helpful to have an understanding of how that information was collected at the engagement sessions, how the people were identified to be engaged with, and then how that information was synthesized, and indeed who made the decision about what to include and not.
Madame.
You're done? Would you like to share? You still have 2 minutes.
Okay. Monsieur Bertrand.
Could I answer that question as well? Yes, go ahead, please do. Well, I would have liked to have been able to say yes, that's what I heard at those engagement sessions, but we weren't consulted. The Congress wasn't consulted. Our opinion was never asked for on this bill. We have 10 affiliates across the country, people who represent their reserves. So I think it's outrageous, really, for the federal government not to have consulted us, not to have consulted the national organization, the Congress of our Aboriginal Peoples, or our affiliates, which are present in all provinces across the country from sea to sea to sea. So I would have liked to have been able to tell you what our members want, what they desire, what their needs are. I would have liked to be able to express those at those engagement sessions, but I couldn't because I didn't have the opportunity, and I think that's unfortunate, to say the least.
Pardon me, MP Arnold Viersen.
Thank you, Madam Chair, and thank you to our guests for being here today. I guess sometimes we end up in this weird place where something's put in front of us and then we're asked, like, well, how would you fix it? That kind of thing. I guess I just would like from all of you, like, basically a thumbs up, thumbs down on this bill. Like, you, Cindy, you've done amazing work, like 88 amendments or something like that. But that doesn't necessarily go to the fundamentals. Like, if this was the bill to propose, would you have proposed it, or would you have gone in a completely different, started out somewhere completely differently? And I know that's a huge question. I'd basically just like a thumbs up, thumbs down on the particular bill. Cindy, I'll start with you.
All right. Again, as a rights holder, I can't make that decision. I know that there are First Nations who have put their thumbs down, and there are some who have put their thumbs up, and some who are saying there needs to be major amendments.
Cindy, your perspective has been interesting, like, for as long as I've been involved in politics and beyond that. You've always had an interesting perspective. Are you willing to do, like, say, take off most of your hats and just, as Cindy Blackstock, give a thumbs up, thumbs down?
What I am prepared to say is that those amendments that we put in there regarding funding, regarding the clarification around the socioeconomic conditions so that can be real, the recommendations around changing of jurisdiction, we see those as fundamental for the success of this bill.
But by doing that, you imply that this is an appropriate bill to be pursued.
I've already gone on the record and said that I absolutely support the aim of this bill.
Super.
But I feel that the text is deficient.
Robert, would you?
I would have to give it thumbs down, and the reason for that is because we were never consulted. I just have a few statistics here in front of me. It states that nearly 49% of the off-reserve First Nations children were in low-income families, compared to 18% of non-Aboriginal children. In Manitoba, for instance, 90% of children that are in care are Indigenous, amounting to something like 10,550 children. In Saskatchewan, there are 5,930 Indigenous children in care. In British Columbia, 1 in 5. There is a deep problem, but I don't think it's a wonderful first step.
Okay.
But they've left so much out. They've just scratched the surface. I'm looking at these numbers here, and it. You know, they're finding a solution for just a very small number of cases where, you know, it should have been more broad-based. It should have included a lot more people.
Robert, I see you wear MP pin, so you know how this place works.
Yes.
To some degree.
I just wear it so I don't have to go through security.
Yeah, I appreciate it. I know how that goes. I know that in some instances I've put bills on the order paper, private members' bills on the order paper, and I've been involved in a number where we go out, do kind of a horizon scan, put it on the order paper to get the feedback, and that what's happening with this particular bill, given the time that there is to an election, given the time that, like, it seems to me if this was something that the government was adamant about, they would have introduced it 2.5 years ago. And it just seems interesting that we are at this place with this bill in front of us, and those issues around consultation and getting agreements with the provinces aren't in place with this particular bill at this point. Could you comment to that?
I don't know why the timing of the bill. You know, it would have been better, as you say, to have it, you know, two or 3 years before, and everything that the government does right now is distinction based. And if you look at if you look at Article 35, there's nothing is said about distinction based. What the Constitution refers to is Indians, Métis, and Inuit. There's no such thing as First Nation. Well, I mean it's there. It's a creation of the Canadian government, but it should be, it should be more inclusive. I remember when this government came into power, the main talking points was inclusiveness, and at CAP we were so happy to hear these things, but it's inclusive for only certain groups of Indigenous people. We wanted, what we wanted is to make sure that the off reserve, whether they be status, non-status, also be included. I'm sure as you already know, back in 2016, CAP won a very decisive Supreme Court battle with the Daniels decision. But we haven't seen the federal government move on that decision so far. We did sign back in December a political accord, and one of the items in the political accord was the ramifications of the Daniels decision, but nothing is moving. So, as you know, to come back to what you were saying, why they waited this late, I have no idea. I cannot answer that. You'd have to ask the Prime Minister that.
We're going to move the questioning to MP Rachel Blaney.
Thank you, Madam Chair. I'm going to pass it on to Georgina.
Thank you very much. I'll get right to the point. The principles of the Human Rights Tribunal, Cindy, they're not in the legislation. What do you think are the impacts for that not being in the legislation?
I think that it could actually potentially roll back the clock for First Nations children, because we have, thanks to the tribunal and thanks to the work of First Nations across this country, we have just as of 2018 been receiving funding at actuals for prevention. They are not, I should say, providing any money for capital, which means is a problem in itself. We could develop a prevention program, maybe host it in a First Nation, but there's no money to build the programs. That's still at litigation. If these principles are not ingrained in this piece, then it becomes a bit of a free-for-all on these funding agreements. And that's a concern for me, because I think that we're finally making progress thanks to the tribunal's decision. And these principles, I think, should be, regardless of political party, everyone should be able to support these for children. I don't know why it's controversial to include them in the bill, to be frank. I think these are fundamental principles about the way that we should be treating any child in Canada.
You go ahead.
You go ahead. Ask any questions you have.
You spoke about the undercurrents of poverty, and I often speak about those experiences also because I see that quite heavily in my riding and throughout Saskatchewan when you go to the reserves and the Métis communities. How can at the national level and at the federal government think about that? How can we still continue to raise these issues? It's not just about housing and lifting water or lifting water, the boil water advisory. It's actually fixing the whole system so that there'll be clean drinking water every day for the reserve. And the list goes on.
I think that's why the Spirit Bear Plan is so essential. I think that one of the things that I think is important to put on the record is in the 153 years that Canada's been around, there has never been a comprehensive plan to reduce all the inequalities that First Nations children, youth, and families face. Never. The Spirit Bear Plan was the answer to that. It was to develop a comprehensive plan, almost like the Marshall Plan after the Second World War, for those of you who are World War II buffs, where the Allies got together and developed a comprehensive plan to rebuild Europe. We say that that's exactly what's needed here. because we need to create that platform of culturally based equity upon which families and children and youth have an opportunity to thrive. My goal is thriving kids. That's what I want to see, who are proud of who they are and who can grow up in their families and get a good education. I think the Spirit Bear Plan is essential to that. Absent a plan, we're going to see the same tendency we've seen for the last over 153 years, and that is governments dealing with the inequalities program by program and drop by drop. And that is, it hasn't worked, right? We still have inequalities in programs. It needs the Spirit Bear Plan.
Thank you so much, Cindy. I just want to recognize the amazing work that you've done for so long on behalf of Indigenous children. And I think when we look at the systems, and I just want to bring it back to the Spirit Bear Plan, because one of the things that is talked about in there is really looking at where that systemic racism is and starting to pull it out. And I think one of the things that is the biggest challenge is because it is normalized, because it has been for so long, it's really hard to pull that out. So I'm just wondering if you could speak to what that would really mean across the board, not only in this legislation, but fundamentally in the relationship between Indigenous communities and Canada.
Right. One of the things we hear a lot is the commitment to reconciliation. I don't question that. I think that many people, good people, are across all political parties and across all walks of life are committed to reconciliation. But as you say, the whole construct of discrimination, this bifurcation of Canadian society into the savage and civilized, which underpins colonialism, is in the DNA of the Canadian government and of the provincial and territorial governments. When we see the Department of Indian Affairs and its descendants, so now Indigenous Services Canada, Crown Relations Canada, and they continue to, for example, litigate against children at the Canadian Human Rights Tribunal, despite making commitments to implement the calls to action. We have to ask ourselves, how can we ventilate these departments in ways that make that racism, structural racism, apparent, and ways that deal with it? I'm not criticizing individual employees. What I am saying is that it's in the system. And so the part of the Spirit Bear Plan is to get an independent evaluation done of the department. A 360 evaluation, never been done in the history of the country, despite its role in residential schools, the 60 Scoop, and Child Welfare Today. Get that done, and then work with departmental officials and with other Indigenous peoples and recalibrate the philosophy and the ways of working within the department and more broadly within the Canadian government and hopefully in provincial and territorial governments too. So we recalibrate that relationship. Because unless you have someone coming in from the outside looking at the department has already proven it cannot reform itself, even if it wants to.
Thank you, and I only have a few seconds, but if there's anything you'd like to add on that issue, Robert.
She is the expert, and
yeah, and I think, you know, the underlying poverty is something that, because it is about supporting the family, and that there is that need for the extra resources just to get anywhere near equitable. Thank you.
Hi, Tom. All right. Thank you so much for coming forward and presenting. I'm sorry on behalf of all MPs for the curtailed opportunity to continue our questioning, but we have been called for a vote. So I wish to, again, thank you. And Miigwech, au revoir. Thank you very much. Meeting suspended, and we'll be back after the vote. Good afternoon. Welcome to our committee, the Indigenous and Northern Affairs Standing Committee of Parliament. We are on the unceded territory of the Algonquin people here in Ottawa, and I come from a land of Treaty 1 and the homeland of the Métis people. And we do that because we always want to remember why we have such critical issues like child and family apprehensions or in care, and the number of Indigenous children in care compared to others indicates that we have a systemic problem. And Parliament is looking to address these issues. So, and as experts, we want to welcome you to the committee. I understand that you're modified. You're going to have 3 presenters, and you're going to do it 7 minutes each or thereabouts. So if we find that another panelist comes in time, we'll invite them to join as well. So that's a little bit of administration to make this work, and we'll get started. So Chief Prosper, do you want to start out and then tell us how it's all going to work out? Okay.
Sure,
welcome.
thank you. Honorable committee members, good afternoon. Gwe Nadaptuk. We're honored to be here on the traditional lands of the Algonquin people. My name is Paul Prosper. I am chief of Buckingham Mi'kmaq Nation. I am here on behalf of the Assembly of Nova Scotia Mi'kmaq Chiefs, which exists as an institution of governance for all bands within Nova Scotia, all 13 bands, Mi'kmaq bands in Nova Scotia. I also, on behalf of the Assembly, hold the Justice Portfolio, and during that time have worked on a number of child welfare-related issues. The Mi'kmaq have our traditional territories called Mi'kma'ki, which encapsulates roughly 5 of the Atlantic provinces. We have a long, rich history. We have a creation story, numerous legends, in our traditional governance structure is the Sante Mawiomi, the Mi'kmaq Grand Council. As Mi'kmaq, we have outstanding and existing Aboriginal and treaty rights. They have been recognized by the highest courts in this country. And throughout our history, our long, rich history, which stems from the treaty periods to scalping proclamations to pre- and post-Confederation legislation, including the Indian Act through residential schools and subsequent policies of the federal government through things like centralization. We are still here. We still thrive within Mi'kma'ki at times, despite the failed good intentions of the federal government. Before the arrival of Europeans, we existed as independent nations governed by our own customs, values, and traditions, and operated through Gizul Korniskam, our creator, who provided us how to live through original instructions as human beings. We have an inherent right to self-government, and this is independent of any legislative enactment. This is also embedded within the constitutional framework of this country through Section 35. With respect to Bill C-92, the Assembly supports the provisions within this bill that recognize the inherent right to self-government. However, we'd like to underscore some fundamental changes that are needed, most predominantly funding and transition-related issues, which my counterparts will sort of get into further. A bit about our experience within Nova Scotia. Back in 2014, the province of Nova Scotia reviewed their Children and Family Services Act, a major overhaul of that act, and we played an important role within that process with the provincial government. This has led to roughly 25 amendments to the Children and Family Services Act that deal with Mi'kmaq people in Nova Scotia, an act that previously had no mention of Mi'kmaq people. We have developed an approach, an interim and long-term approach. The interim approach was to gain some recognition through the Provincial Act, with the long-term approach being a Mi'kmaq law over Mi'kmaq children, certainly consistent with this bill. Through those amendments that we have achieved in 2017, we have positive sort of outcomes. For example, there are less foster care placements, more within the area of customary care. We have recognized family group conferencing, which exists as a preventative measure through Mi'kmaq traditions, which allows us to take into account existing situation before it gets to the point of no return. But saying this, we are cognizant of the fact that we certainly don't want this federal act, this bill, to interfere with the substantive gains that we have made provincially. With respect to my experience, just a note on connection and the role of community. As a leader, as chief, we often get tired of watching children, families, and communities get torn apart by a system that doesn't work. And certainly as my role, we recognize the need to have basic building blocks, including identity, culture, language, traditions, related to the spirit and well-being of our peoples and of nations. There's a need for connecting and belonging, which is a basic right for community members to live in health and safe environments. And we recognize that the solutions to the problems we have in child welfare must come from within. They must come from our own respective communities to resolve these issues. So there has to exist a certain environment, because we all know too well that at times provincial laws and policies don't reflect the realities within our communities. We recognize that self-government can provide a mechanism that offers traditional and practical ways to care for children and families. And certainly there are a number of examples in that regard. Just a quick note on funding and transition. We recognize that legislation in and of itself does not really create the change that is needed. It has to be additional approaches involving education, capacity building, governance, infrastructure, stable funding, and building relationships within an overall strategic justice initiative. With that, I like to conclude and offer comments from my colleagues here. Thank you.
All right. You have 7 minutes. And then Ms. Cox, Jennifer?
Yes.
Go ahead.
So my name is Jennifer Cox, and I'm a lawyer, a Mi'kmaq lawyer, and I've been working in the province of Nova Scotia, although I worked for a number of years in the province of Saskatchewan as well. So 24 years this June will be when I first started practicing law. I've done a lot of work in the area of child welfare, and in fact, Mr. Morris, who is on the other side of the chief, and I would be on the opposite side of child welfare files. So part of what we wanted to share with you today is not only our comments on Bill C-92, but also our experiences in relationship building, because you wouldn't normally see lawyers who are on the opposite side of a case working together. But we have formed those relationships and have been able to make some of the changes we see in Nova Scotia now based on those relationships. So my submissions to the committee are with respect to the substantive provisions of C-92. We did prepare a brief and submit it, but unfortunately it hasn't been translated, so you don't have it before you. But as the chief has indicated, we're supportive of, the instructions I have is that we are supportive of C-92, but there are some suggestions to change. And based on our experience in Nova Scotia with the legislative changes there, we're not sort of unaware of the fact that these things happen very quickly with very little opportunity to participate in the process. So I think to some degree the committee needs to take some that into consideration when you're looking at sort of the motivations behind the government bringing this forward in such a short window. Definitely difficult for us to participate with not a lot of time, but at the same time, this is not atypical of government to bring it forward and try to push it through. In Nova Scotia, when we dealt with the changes in the legislation, it was very quick. We had a couple months, but we did the best we could. We came forward with some suggestions, and some of those suggestions have led to some really positive changes, which my friend Mr. Morris will talk about in terms of the level of kids in care and that things going down, and much more positive outcomes for families. But that's because of the relationships, because we have one agency in the province. We have a good relationship with the province of Nova Scotia. We have the Assembly of Nova Scotia Chiefs, and obviously a good champion with Chief Prosper. So there's a lot of pieces to the success story that we have in Nova Scotia that isn't just based on legislation. So I'll get into the substantive provisions of the legislation that we see needing to be looked at. And I think it's important, too, for the committee to note, we don't see this as co-drafted. So C-92 was not something that we had anything other than one opportunity. There was an engagement session in October of 2018, but we don't see this as co-drafting. And I also, as I've indicated to you, do not see legislation as being the only agent of change. There's going to have to be the relationships, the funding, the infrastructure, the transition, all of these other things. So we're asking that funding provisions be added to the preamble. I think the word need needs to be substituted for call. And again, all of these substantive provisions are going to be provided to you, so you can take the written text and look at it. Section 18, we're asking that the provisions from the preamble be brought into Section 18 as well. So that's the jurisdiction provisions. And we're not asking for changes in wording other than the one word need be inserted. We're using the preamble, the language that the Government of Canada has already put forward. We're asking that Section 22, sub 2, sub C also include the provisions with respect to funding that are principles. They're not formulas, they're just principles. If those funding principles are not included in the legislation, it makes it very difficult for us to negotiate those coordination agreements. We're asking that in Section 18, sub 1, the United Nations Declaration on Indigenous Peoples also be included as the recognition tool. So not only the Section 35 of the Constitution Act, but also the United Nations Declaration on Indigenous Peoples. We're asking that Jordan's Principle be specifically mentioned in Section 9, sub 3, sub E. We have some suggestions to the best interest of the child, Section 10, sub 3, which will allow some space for the inherent Indigenous legal and community standards in that section. That's a fairly important piece of the bill, and I think it's really important to give Indigenous communities some space to allow for their own community standards and traditions to be interpreted while their own legislation is being drafted. A lot of these provisions won't be applied if they have their own legislation, but in the meantime, there's going to be a transition period, and there should be some opportunity to allow for those inherent legal and community standards to come into play. Section 10, sub 3, sub G, we have concerns about, and I think, quite frankly, it's in the wrong place. Normally you see family violence as a reason to remove children in provincial legislation, not in a best interest section. So we are recommending that it be deleted because it would appear that it would confuse people, or it may very well confuse people. The definition of care provider, unfortunately, appears to include allowing foster parents to have standing in a legal proceeding. That's not normally what we see, and in fact, where most provinces and territories in Canada do not permit foster parents to have standing in a legal proceeding, except for in Manitoba, and there are lots of problems and delays that are caused by that. So those are concerns. The definition, and we've provided you with the specific wording that is amended. So that's the definition of care provider, so it's in the definition section. So we've specifically, and we've proposed specific suggestions to change that. Section 31, sub 1, the 5-year review provision, we're asking that it can be considered to be 3 years instead, because there are a number of different things that have to be looked at here. And we also are looking for some, we've given you some suggestions with respect to the notice provisions, so section 12. We have a notice, a ban notice, and a form that has been co-developed in the province of Nova Scotia. We provided you a copy of both the notice and the response that the bans can complete. We think that that might be helpful in terms of section 12 and what we can do when we're given an opportunity to participate. So the province of Nova Scotia and the family courts in Nova Scotia did give us an opportunity to participate in that type of process. And those are the types of, that's the work we were able to do when we worked together. So those are my comments.
Mr. Paul Morris, 7 minutes.
Yes, thank you, Chair. Thank you to the committee for, I guess, inviting me at the last minute and allowing me to join the panel. I have practiced in the area of child protection for 20 years. I've been in-house legal counsel with Mi'kmaq Family for the last 3.5, who was my primary client prior to going in-house. And I guess one of the reasons why the chief asked me to come along today and asked me to join the panel is to just talk a little bit about some of the changes that have been made, because there are the amendments that happened in Nova Scotia to the legislation, which are significant and important, but they just happened in March 1st of 2017. So it's at the beginning stages in terms of what that means for change. But certainly in the 20 years that I've been involved with litigating child protection matters, I've seen a change within the agency within Nova Scotia. And when I refer to the agency, Nova Scotia, for those who aren't aware, has an organization called Mi'kmaq Family Children's Services that's through a tripartite agreement between the province, the federal government, and the 13 chiefs. They provide all family and children's services for the Mi'kmaq who reside within the geographical communities within Nova Scotia. So it is a situation in Nova Scotia where there is an existing agency that provides child protection. However, they currently are providing that service under a provincial mandate. We don't have a separate policy manual. We operate under the province of Nova Scotia's child protection manual. And so initially this was something that certainly when I started doing this, it was fairly rigid in terms of how it was applied. And often would result in more significant intervention taking place, resulting in more taking into cares occurring. Much of this had to do with when you were looking at extended family placements, the policies that were in place in terms of having checks done in advance before children could be placed with families, having situations where a criminal conviction from 7 years ago, even if there's been no issues over the last 5 years with children living in that home, that person couldn't be considered as an extended family placement for children that couldn't remain with other family. And so one of the things that we've seen without the legislation was the province worked cooperatively with our agency to do representations to INAC, or the organization that preceded INAC, to obtain funding, because our agency was underfunded. The number of case files per worker was well beyond the provincial average, and so our workforce was substantially increased. And this resulted in an ability for the agency to begin, I think, to provide more less intrusive, more and better service to the families that they served. It allowed workers the opportunity to take the time to locate and explore family placements before taking children into care. And when I say time, often that's just 3 hours, 4 hours, that an afternoon that's taking place, instead of intervention happening quickly, children being placed in care, and then a long, laborious process to clear placements to allow the children to go home. And so the practices and the policies that were in place changed how child protection services were delivered, children and family services were delivered within the communities. And the change resulted when I started doing this in the late 90s, early 2000s, the majority of files where I was going to court were temporary care and custody files. Children had been taken into care. The agency would be providing services to address those issues before the children could go home. If it was going to be a longer period of time, it would be weeks to months before family placements could be approved. Once the workforce was increased, the funding was increased, and the level of service was increased, the agency was able to focus on, okay, how can we better meet the needs of the families and children which we serve, and find a way to keep children with their families, with their communities, and try to reduce the number of removals. So I did tally the numbers. I don't have the numbers from when I started out because I was one of the junior lawyers who was working on the files that the lawyer that I was working with would assign. But when I tallied the numbers last year, 46% of our files were supervision orders, which means the children are still with one of the parents or both of the parents. 49% were supervision orders. 26% were customary care supervisory orders, which mean the children were not taken into care but placed with extended family, someone else within the family of the children. We had 13% of our kids that were taken into care were in kinship placements. And again, this would have typically surrounded a funding issue of some sort where we would have extended family who couldn't afford to care for the children under a supervisory order because there was no funding associated with supervisory orders. You only received funding if the kids were taken into care. And then we had 12% last year that were true temporary care foster home without family. Almost a complete reversal from 20 years prior when I started doing this, where 75 to 80% of my files were temporary care and custody. Now 75% are family placements, with half of the temporary care and custody placements being with family. So we do see this as an opportunity with the rights recognition. The funding piece is going to be key because it's those provision of services to the families that will affect the real change for families. And that can be done through policy as well as legislation. So I know, I think I'm at my 7 minutes, so I'll wrap it up there. I think the main reason that I was asked to join the group today was to sort of provide some of that information. Yeah, thank you very much.
Thank you. And a special recognition for Dwayne Smith, Chair and Chief Executive Officer of Anuni Valley. I'm going to practice. Anuna Valley. Oh, it's still Regional Corporation. I'm so sorry. And you've taken a position to come a little bit early, and we put you with this panel. We really appreciate that, and offer you the full 10 minutes, if you like, to present.
Thank you, Madam Chair, and to the committee. I apologize to the others here for crashing your presentation, but thanks for the opportunity, first of all, and I'll try to be as brief as I can. Some of my opening comments I said to you a few weeks ago. I didn't realize it was the same committee that I'd be speaking to on different matters, but as the chair has noted, my name is Dwayne Smith, my English name anyways, it's Dwayne Smith. I am the chair and CEO of the Invervalley Regional Corporation, which represents the very far northwest of Canada bordering Alaska. The area I represent is about just under 1 million square kilometers, 2/3 of that being a water body. I'll cut to the chase on some matters so I can spend some time on some points. As you're aware already, we signed an agreement. When I say we, Canada and ourselves signed an agreement for us to implement the agreement arrangements that we had under the agreement together, which is called the Inevaluate Final Agreement back in 1984. It's the second oldest modern day treaty that we have within Canada. As I've said, and I'll reiterate it again, that the IFA belongs not only to the Nunavut but to Canada as well. So that's why I'm partly pleased to be here sitting before you today, because it's Canada and ourselves that have to work together on issues such as what I'm here to talk about together, on how we can improve and implement our obligations under that treaty. The ISR itself has 6 communities. I'll skip over parts of it, and I do apologize to the interpreters as I'm cutting and pasting due to me injecting into this section here. We do have roughly 63 or 6,400 Inuvialuit scattered across the country, mostly within our region. In regards to supporting Inuvialuit children, before I get into that part, I was sitting in the back listening to the Mi'kmaq presentation, and I can't state enough my support for the comments and the recommendations that they've made to date, because I've heard similar recommendations from other parties, including other Inuit organizations. I would like to turn to some of the things we have been doing to try and support our children, youth, and families in the ISR, as it's referred to, or the Inuvialuit Settlement Region. One of the 3 principal objectives of the IFA is to preserve Inuvialuit cultural identity and values within a changing northern society. Healthy families and communities where children and youth feel included and supported are essential to the preservation of cultural identity and values. As most of you may know, since 2014, the Auditor General of Canada has identified serious deficiencies in the delivery of child and family services in the Northwest Territories and in the structures intended to support this delivery. These findings disproportionately impact Indigenous children in the territory, as over 90% of the children in care are Indigenous. At that time, the Auditor General also said that this government could not even identify where some of these children are located. And then last year, 2018, the Auditor General did another report, and the basic findings were that it was actually getting worse. So I don't know how it could possibly get too much worse, where the government could not even identify where some of these kids are being kept in custody, but now it's getting worse. So IRC has been doing what we can to manage these deficiencies so that our kids do not fall through the cracks. One example is us providing what we call student and family support workers. The SFSW was identified as a need for schools to connect with families and communities, and I made it a priority when I was first elected in 2016. We used the funds we receive to maintain 1 staff person for each community. These individuals work out of the schools and provide assistance to students and families of students to ensure Inuvialuit kids are getting to school and are supported through their school years. Another example, since I became chair, we have been trying to work with territorial and provincial governments to ensure that children who become government wards or who are adopted into non-Inuvialuit families get a chance to register and ultimately enroll with us. In some cases, Inuvialuit children are removed from their families and sent to places from where it is very difficult and expensive to return to the ISR. Once we find a child in the system, we try to reach out and provide materials about our 3 Inuvialuktun dialects, the history of the region, and traditional activities. When our records show that a child is about to turn 18, we ensure they have the forms they need to apply to the Inuvialuit Trust. Our staff remains on hand for any guardian who wants to know more about the IRC, the ISR, and our Inuvialuit communities. I'll digress again here for a moment just so you understand the government system where a child that turns 18 is put into a hotel for a period of time, and then they're left on their own after that to look after themselves without being given the basic skills to do so. So we do have a problem here. Before Minister Philpott's emergency meeting and the attention that the development of this Bill C-92 has brought to the issue of facing Indigenous children, youth and families, it was very difficult to get traction with some provincial and territorial governments. While individual staff members were well-meaning, the framework for involving Inuvialuit organizations and sharing information was weak. Bill C-92 is not perfect, but it is an important step. In our case, we hope that it will provide guidance to the GNWT, Government of the Northwest Territories, as it sorts through the many increasing deficiencies that the Auditor General has identified. Comments on the bill. I'll turn now to a couple of key elements. As noted above, the transmission of our culture, language, as well as knowledge and appreciation for our region are key to preserving Inuvialuit cultural identity and values within a changing northern society. The principles under Section 9 of the bill give appropriate weight to these things. In particular, we see subparagraph 9.3d, which acknowledges a role for Indigenous organizations as essential. Section 12 of the bill, which requires a service provider to provide notice of a measure to the child's parent and the care provider, as well as to the Indigenous governing body that acts on behalf of the Indigenous group, will greatly benefit the work that we are trying to do on behalf of Inuvialuit children wherever they are. With this section, I would note that implementing the regulations are going to be important. My staff tell me that an obstacle in getting information to Indigenous organizations are the intake procedures of the responsible jurisdiction. In some provinces, Inuit do not even have a checkbox that the social worker could mark. All kids are simply First Nations. So we have a branding problem here. The categorization of Indigenous children within the various databases will have to be done on a more granular basis. This is the only way that social workers will be able to connect the child with the relevant Indigenous organization so that notice can be provided. Section 16 of the bill addresses the priorities considered in the placement of children. Because of our remote location within Canada, and the difficulty children have in visiting their home community once removed, Inuvialuit would like to see some priority placed on geographic proximity of the placements. If this is not possible, then we would like to see some provision for maintaining the connection between the child and the home community or region. As a final comment, as we are working through some challenges in our self-government negotiations, we note the importance of the coordination agreement provisions under Section 20 of the bill. These provisions would allow the IRC to request a coordination agreement with government in relation to the exercise of the legislative authority on, first, the provision of emergency services to ensure the safety, security, and well-being of Indigenous children. Second, support measures to enable Indigenous children to exercise their rights effectively. Third, fiscal arrangements related to the effective exercise of the legislative authority. And lastly, any other coordination measure related to the effective exercise of the legislative authority. The ability to exercise our traditional governance over child and family services, as it is called in this modern age, is key to ensuring our children have a sense of identity and belonging. In conclusion, we look forward to working with the federal government in the development of the regulations that will help implement this act when it comes into force. Thanks for your attention and interest, and I'm happy to take questions. Karina, thanks.
All right. We move on to the question period, and we start with MP Dan Vandell.
Thank you very much. Thank you, all of you, for your fine presentations, and welcome to Ottawa. First question, I'll go right to Dwayne Smith because he's freshest in my mind. Generally, you're supportive, and I think the words you said, it's not a perfect bill, but you're supportive of the bill. My question to you is, who currently administers child welfare in your territory? Is it the federal government?
Sorry, no, we're a territory, so it's
so-
the government of the Northwest Territories.
Okay. And so, okay, you've made your points quite clear. That I didn't, for some reason I didn't get that. I'm sure you mentioned it, but I didn't hear it. Chief Prosper, I understand you were on the AFN's legislative working group that worked on this legislation. Can you describe what that was? First of all, is that correct? And if it is, can you tell me what that was like?
Yes, I was a member appointed by the Assembly to sit on the Legislative Working Group. As I understand, it's a group of Aboriginal representatives, First Nation representatives from across the country. And, you know, there were some meetings we had collectively to discuss the bill. I'd just like to echo the comments by Ms. Cox in the sense that it wasn't a joint exercise in terms of co-drafting. And in terms of the input with respect to the bill, there was a meeting where issues were brought forward constructively to various government representatives, and that was pretty well it, from my understanding. I think Ms. Cox, who is a member of that same group, might be able to provide further details.
Ms. Cox, you were on the group as well?
I was, yeah.
Okay, can you tell us a bit more about the process?
Well, it was basically the best we could do in the short timelines we had. So, you know, dealing with everybody, bringing everybody together, sharing the information. Everybody was putting forward the positions that they had in terms of what they felt the drafting instructions should be for Bill C-92. And once the consultation bill was provided, we were given approximately a week. It was given to us before it was tabled, and we had approximately a week to look at it. You know, it was the best we could do. We had a very, very short period of time, and it was, I suppose, fairly effective given the short amount of time that we had.
I understand, I believe all three of you, Ms. Cox, Chief Prosper, and Paul Morris, have identified funding as an issue. Now, the rationale, what we're hearing from the department is that we are trying to essentially redesign the child welfare system, and that funding to identify funding right now would perhaps be premature. Rather, let's see what sort of models come out. My question to, I guess, all of you is that when you say funding, are you talking precise dollar figures or funding principles be embedded in the bill? If that's your suggestion, maybe I'll go to the chief first, Paul.
My understanding is yes, not a definitive amount, but more or less funding principles to help guide later the provision of adequate services and programming.
Paul, do you want to add something?
No, I agree with the chief's comments on that. I think I don't think putting a number in the legislation would be a good idea, and I think formulas are somewhat concerning as well. So I think the key piece is ensuring that there is that clear obligation that funding will be provided, so that we don't end up with a provision that's providing for a service that people can't provide. So.
Okay.
Yeah, so unfortunately, because you don't have the brief, we've actually made suggestions as to the wording, which we're just pulling the preamble, the wording from the preamble on the funding provisions into the actual body of the bill. And it is just the principles from, primarily from the Canadian Human Rights decision, the sustainable equality. But it's just the principles. We're not looking for anything specific, but because there's nothing in the body of the bill that speaks to the specific, to the funding itself,
Okay.
this is what our concern is.
All three of you have also mentioned the new legislation brought in by the province. It sounds like it's been a positive initiative. Could you talk about the role of the province in this legislation, how you see that unfolding, and do you have any thoughts on that?
As mentioned earlier from within my opening comments, I believe we have a good working relationship with the province, and which helped facilitate the process we went through with the Children and Family Services Act. We had discussions with the province prior to coming to this committee, and those relationships still continue. Basically, what we are quite mindful of is some of the gains we made provincially through provincial legislation. There's some areas within this bill that will impact that. So we just wanted to be, and we're prepared to outline and have outlined those issues. But that's one of the concerns we wanted to share.
We need to move questioning now to MP Kathy McLeod.
Thank you, and thank you to all the witnesses. I have a lot of different lines of questioning I want to head down, but I do want to pick up on what you just said, Chief Prosper. What areas might create challenges? We all know that different provinces are in very different positions. So what in this bill might create a challenge in terms of your current relationship with the provincial government?
Thank you for that. If I can defer to Mr. Moores, who certainly can articulate that better than myself.
Okay. I don't necessarily see it as creating a difficulty between us and the province. The concern, I guess, that I think we see is that we have in the amendments a notice to ban that's being provided, and so when our agency starts an application, I notify the band that we're intervening. This is the type of intervention. This is who the child's being placed with. And when I see in the federal legislation that there's going to be notice provided, but no identifying information, and I'm trying to equate how do I put the band in a position to step in and start to assist? Because in a lot of cases, when we provide that notice to band, the band can reach out to the family and find out is it a housing issue, is it a financial, those types of things, to begin to intervene. So that's just, I guess, one thing that is of concerning nature. The other, which was mentioned by Ms. Cox about the definition of care provider, the legislation in Nova Scotia currently clearly outlines that a foster parent is not a party to a proceeding. So you don't get into these. The goal is addressing the protection issue and transitioning the child back to the original caregiver, back to the family member. And when that issue has been addressed to the satisfaction of the agency, the family, and the court, we're concerned if a foster parent under that care provider definition would suddenly have standing. As we've heard, that's an issue in other provinces that don't have legislation that says a foster parent will not be a party in those proceedings. So those would be two examples of things that would be concerning, where this legislation would take priority wherever it conflicts with the provincial legislation.
Okay, thank you. You said, I think, the jurisdiction is in geographical communities. Is that only on reserve, or is it the whole?
On reserve.
So would you see opportunity under this legislation, enabling opportunity to allow some work off reserve? Is that potentially a positive?
I think the long-term goal of the initiative that's going forward in Nova Scotia is for that to be the case. And this would get back to the funding and manpower issue, as we currently have the manpower to deal with on reserve. About half of the Mi'kmaq population, I think, lives off reserve. Geographically, I don't think it's an issue because we are all over the province anyway, so it's not that we're relying on Department of Community Services for the province of Nova Scotia geographically. The issue would be the amount of files and that sort of thing. So we'd have to ensure that we have funding to grow the organization and grow the infrastructure for it to provide those services.
Thank you. Ms. Cox, you talked about best interests of the child, and we also had a lot of conversation about best interests of the child in our previous committee. I don't know if you were here to hear that dialogue that went back and forth. And it sounds like there is some issues there. Can you talk a little bit more about your concern as it's written, best interests of the child?
Well, with respect to section 10 sub 3, we've asked just to add a little bit more wiggle room into the beginning section. So where it starts, to determine the best interest of an Indigenous child, all factors related to the circumstances of the child. We say shall first be determined by the inherent Indigenous legal and community standards. So this is where I say giving some room for the communities to immediately allow recognition of their standards. So in the best interest section. With respect to the substantive equality and cultural continuity, those are good principles, but they're not in the best interest section. They should be cross-referenced in the best interest section because best interest is given some paramountcy or some significance within Bill C-92, and because those cultural continuity and substantive equality are those are good principles, they should be in the more substantive piece, which is the best interest. And finally, my other concern that I mentioned was the family violence piece, because it's in the wrong place. I don't know what else to say other than when we do child protection files, or when we look at child protection files, we look at the reasons why a child should be removed from the care of their parents. Family violence is usually one of those reasons. So it's not a best interest issue. It's more a reason for protection concerns. Those provisions are in the legislation across Canada. We don't need to add anything more on that factor. I think it goes without saying that we would see that children should live without boil water advisories, without family violence, without some of these protection factors. So it's just not in the right place.
You said you were given the bill a week before it was tabled. Mm-hmm. That was the full copy of the bill, was it?
Well, that was the they called it the consultation draft. It doesn't necessarily reflect exactly what's in C-92 now. There were some changes that were made in that week, but there were also things that were added to it that we had never seen before, and one of them is 10.3G. The family violence provision was not at all mentioned in the draft consultation bill.
Okay. Mr. Smith, it's a puzzle that things could go, the auditor brings something up and it goes from bad to worse. Have you got any sort of sense of how things are continuing and why they're continuing to spiral from, bad to worse? Typically governments take Auditor General's reports very seriously.
Well, I'm not the government. Of my area, I can't answer that, but the observations and the recommendations are in the Auditor General's reports. But the reason we're supportive of this legislation right now is we want to finally have our rights recognized to look after our own children in a process that we could come to an agreement on. And yes, that would include infrastructure and investment in our organization, where we could possibly take this on again in a process that we can work together, because at the very least, I don't think we can do any worse. We were doing pretty good raising our kids 150 years ago, so I think there's an opportunity here for reconciliation to be a very strong part of how Canada progresses with both of our obligations to implement the IFA at the very least as it pertains to the welfare and the well-being of the children of my region.
We need to move questioning. Questions now go from MP Rachel Blaney.
Thank you, Chair, and thank you all for being here today. I really appreciate your time and your testimony. We've heard a lot today about the concern around funding. And, Cindy Blackstock was here earlier, and what her recommendation was, let's look at the principles of the Canadian Human Rights Tribunal, which really talk and speak to having equity for Indigenous children that's comparable to all Canadian children. I'm just wondering if you have any thoughts on having something like that in the legislation directly.
From my perspective, the provisions, the preamble does a fairly good job of recognizing the substantive equality that comes out of the Canadian Human Rights decision. So we don't have a lot of qualm about the wording that's in the bill. There's one change that we're suggesting to that preamble that speaks to funding. It just needs to move into the body of the bill, because in the preamble, it doesn't have the same strength legally as it does as if it's in the bill, and we're asking that it specifically go into both the jurisdiction provisions, the recognition of the inherent right, because you need funding to assert your right, and also when it comes to negotiating your coordination agreement. So when you're taking on the responsibility and you're negotiating with the territorial and provincial governments, you include the funding provision that's based on that substantive equality. So when you get a chance to see the written submissions we've made, we've actually suggested text on that.
Thank you, and I think it's important that people understand that if it's in the preamble, it's not the legislation, and that is the biggest gap that you're identifying for us there. I'd like to come back to Mr. Smith. You talked about the geographic region in Section 16 of placement of children and looking at the geographical area and where they're going to be placed. And I'm just wondering if you could talk about that. And I think it's important to get it on the record. I represent a more rural and remote community. You take that to a whole new level compared to my region, but a lot of people don't understand just how far away that can be and what that means in terms of access to community, access to other relatives. And so if you could just speak to that and why that's so important in this legislation.
Yeah, thanks for the question. I always say that it's 9 hours by jet to get to my community, but I'm still in the same country. Mm-hmm. To give you some perspective, it would really help. I think that there was regular tours of people like yourselves in your positions to visit different jurisdictions of the country, so that it's understood just how vast and the issues that Canada has to undertake on this scale. But in my area, the head service, initial service center would be my community, but if it can't be addressed there, then it's sent 800 kilometers south, if not more, to Yellowknife, which is the capital. And then there, which still has limited ability to provide various services, the individual needing some kind of a health service is then sent to Edmonton, which is 3,200 kilometers south of me. And some of these children that we're talking about, of course, let's be fair about all of this, may have FASD or whatever it is, where you're not going to get that specialized service, etc., within small communities or jurisdictions like my own. But at the very least, they should look at how to explore how to keep them closer to home. But then for children that are taken because a mother and a father had a spat and the social worker doesn't think that they have the ability to look after them, then that's where the system is failing us, where our rights within our area are not being recognized or respected, regardless of this legislation, because we have that right and recognition already within the IFA. It's just that the governments, both federal and territorial, are not respecting it. Mm-hmm. And we've not had this process to sit down like we are now to come up with an opportunity to discuss developing improved processes that reflect our culture, our ways of addressing such issues, and for us to have the opportunity to look after our own children first of all, so that they're at least kept in a cultural environment, so that their identity to themselves is understood and they're exposed to the culture. But geographically, it's a different scale here.
Yeah, thank you so much for that. The last question I have is, earlier you were speaking, Chief Prosper and Ms. Cox, about this was not co-drafted. And I'm just wondering if you could expand on what you mean by that, and maybe use the example of what you've done with your province, and look at how those things could be done in a more supportive way.
Well, I think if we look at, and this is also something that we've attached for your information once you get the translated version, is the notices that were developed. So the co-development meant we actually sat down and looked at draft forms, and we all worked together to and asked and had our ability to include what we wanted in this. So especially the form that comes back from the band and what is in that form, because we wanted to generate support from the community, and we wanted to ask the right questions in the form so that the community knew that the court wants to know about this, the court wants to know about that, what can we offer. So that's an opportunity of co-drafting, because we looked at the documents beforehand and we all had an opportunity to collaboratively determine what we wanted in them. When it came to C-92, we were given it a week before. We're all working off the corners of our desk, because this is not something I can pay attention to, within the scope of everything else I'm doing all the time. It's burning the midnight oil looking at C-92. That's not an opportunity to really give the proper input, and we could have made some suggestions, as we have now been able to do, that maybe would have been helpful. So, even given us a month or two to actually look at a draft bill and then have some input and make some suggestions, because maybe we do have some good ideas and we could come to some sort of consensus, or at least have the opportunity to feel like we've been heard and not rushing it's just not, nothing's perfect. We're all under a lot of pressure, but to, have the opportunity to sit down, look at something, have some opportunity to provide some input, that would be all we would have been asking for. That would have been more like co-drafting.
Thank you so much.
Thank you. We now move to the 5-minute round. Nope, sorry, we've got one more 7-minute round with MP Robert Falcon-Ouellette.
Hey, thank you very much for coming today. I very much appreciate it. I'd just like to highlight some testimony we heard from Laurie Sargent from Justice Canada, where she did say this is the first time, really in Canadian history, where a government has made such substantive changes and speaks to such a degree to Section 35 in actually starting to fill that out and breathe life into it. So I have very quick questions that I know. I'm just going to try and go through them very quickly. So people who live outside the community, who should have jurisdiction? If people do not live in your community or in your reserves, who should have jurisdiction?
Just a point of clarity, do you mean, for example, Mi'kmaq people?
Yes, of course. Yes, I'm speaking you as the rights holder for the Mi'kmaq people. You have someone living in Toronto or in Halifax who's not living on in a community. Who should be the one providing that service?
Well, we believe as leadership that we have jurisdiction not only within the confines of our respective communities, but throughout our traditional territory, which would be inclusive of quote unquote off reserve members. So we assume that jurisdiction and control over them.
Would you be passing, if that was the case, would you be passing, what would be the legislative process that you would go through with your community? You have a large community that moves over a number of provinces. Do you have a legislative process that you would be able to enact laws in order to breathe life into managing those services for community members or the people who are your citizens?
Yes, collectively within Nova Scotia, we have the Assembly, but we also have a variety of governance structures that support it. And one of those structures involve the what is referred to as the Made in Nova Scotia process, where we're in negotiations with the federal and provincial governments over rights-related issues. This is governed through a framework agreement, and part of our within that framework agreement, child welfare is one of the issues. But certainly, with legislation of this nature, this would expedite that process in terms of us coming up with laws over our respective membership. And certainly we've made inroads to do that in areas such as moose management, things of that nature in terms of filling the legislative void.
So I'm understanding then that this could actually strengthen the self-government and self-determination of the Mi'kmaq people.
Most definitely.
Very good. Actually, I have a few questions for Mr. Smith as well. I wanted to talk about customary adoption. Obviously, Indigenous people used to practice a lot of customary adoption. Many people in the southern parts of Canada do not practice this because it's very difficult to obtain this through the courts because it's not mentioned in any Canadian law really. If that was mentioned in this law, would that expedite processes in which people do still practice customary adoption with Inuit peoples?
Thanks for the question. In reality, we still practice custom law. If your grandparent wants one of their children's children, then they take them, and it's agreed upon because they feel that they have the better skill at that time in life to give them adequate upbringing. I'm one of those children, so just to let you know. But it actually is within my government's area that custom law is supposed to be, it's recognized, but they do not practice it. So we force it on them on occasion.
On the courts?
On the government.
On the government.
We hope we never have to go to the courts, but when we have to stress that a certain families want to practice the custom law, that's where we have to have a discussion rather than the GNWT, the government of my area, just exercising that process with that family. So it exists, it's just not being properly implemented.
Actually, I have a few more questions related to, for instance, I got 2 minutes, yes, minute 30 seconds. Courts. So, Ms. Cox, you mentioned that you have to go through the court system. Would this bill prevent the Mi'kmaq people or the Inuvik Regional Corporation or peoples from setting up your own court system in relation to Child and Family Services if you pass law or legislation saying this is the process, we're not going to use the courts, but we're going to set up our own type of tribunal to decide these matters among ourselves? Would that prevent you from doing that?
Well, no, Bill C-92 would conceivably give you the ability to set that structure up for yourself, which would include the courts, but there's going to be this gap between what we have now and what we have whenever you can get the resources in place to get your government, your laws and other things in place, right? So we have to look at that interim period of time. And when I make reference to some level of court being identified in the legislation to adopt pieces of, or to work with C-92, because there is going to be this gap. And some communities are not going to be able to come forward and get their laws in place as fast as other communities. Some you're going to see do really quickly because they already have them pretty much. They're just waiting for the recognition. So I don't see anything in C-92 that will prohibit.
Okay, and I just have one final question for Mr. Smith. Children too old. Obviously, we talked a little bit about prenatal care from, it was mentioned a little bit earlier in some of the questioning. Should we have some mention, up to age 21? I know often in INAC or Indigenous Services often considers an education up to 21. Should there be some provision for, people who are between 18 to 21 to continue on to be well set up to succeed as an adult in that crucial time period?
Quick answer, yes. Secondary response to that is you can't just have a blanket process for it, I would think, because every individual's case is going to be different, and you have to recognize that there needs to be a potential process to assist those going into that transition period, because all you might be doing is kicking that can down the road for three more years, and the situation still remains the same. If the child is mentally challenged or something like that, they're going to need ongoing support. So you can't just abandon them because they've hit a certain age.
Okay. We move questioning now to the 5-minute rounds, and we're being generous. We're over the 1 hour period because we have a robust panel. I hope it's working out for your personal schedules. And I'm going to suggest, if I have agreement, for another perhaps 2 questioners, 5 minutes each, and then we wrap up. MP Kevin Wong.
Thank you, Madam Chair. You mentioned this wasn't co-drafted, so there really wasn't any discussion, or was there, previous on the funding situation? So maybe, Ms. Cox, if you could pick up on that.
Oh, there was discussion because there was all kinds of information sought by the government through their various engagement sessions, which they list that they in every one of them. Although I wasn't at all of them, you did mention everybody has talked about funding. It's been front and center because that's the main concern that all First Nations communities have is funding. So did we mention that we wanted funding in the bill? Absolutely. When we saw the draft bill the week before, absolutely we asked to have funding inserted. It wasn't inserted.
We've heard some discussions off reserve. How does that affect your people with this bill? Those living in communities off reserve.
Yes. Well, you know, as leadership and from the Assembly's perspective, you know, our communities have, there are community members regardless of where they live. They don't stop being Mi'kmaq by virtue of leaving the boundaries of the reserve. And so, you know, we would look to, as mentioned earlier, to work towards providing some jurisdiction with respect to our membership off reserve. Obviously, that will involve discussions with our counterpart, the province of Nova Scotia, but also from an organizational perspective, various organizations that serve urban areas and things of that nature.
Do you have the capacity to do that? Some regions in this country can't. They simply don't have the capacity.
There's an intimate link between jurisdiction and funding, as subject to what was mentioned before. So, you know, and learning from the provincial experience, you know, it's one thing to have legislation. It's another thing to implement that legislation. And the key there is capacity and having the appropriate funds and support and infrastructure to breathe life into these into the laws that are developed. So that's the caveat I would add to that.
Yeah. You know, this bill, it's gone through 2 ministers. It's gone through quite a bit from day one. You've had some recommendations. Any other recommendations? Like the Mi'kmaq, you guys are really organized, if I don't mind saying that. I mean, I look at some other regions, and Ms. Cox, you said you were from Saskatchewan at one time. We have different issues than you have in Nova Scotia, as you know. So what I'm seeing here with this bill, and it does concern me, there are some regions that are very capable of picking this bill up and immediately hit the ground. And there are some regions, maybe the majority in this country, that will be further behind with this bill. How would you fit in with that?
With that recognition of the difference nationally, one of the things we stressed within our submissions is relationship building and there were a number of pivotal things within the history of the Mi'kmaq, not only within the Atlantic, but also within the context of Nova Scotia, that facilitated a relationship on a tripartite basis between the federal, provincial, and Mi'kmaq governments that we were able to carry on forward in a variety of areas. And so there's been a lot of water under the bridge. We were subject to litigation like other people. We were successful in, various court actions. We're engaged in a tripartite negotiation process. So we recognize the need, and obviously our treaties of peace and friendship stress that idea of coming together and working out differences. So, I only put that forward as an example for what it is, and certainly hope that our counterparts throughout the rest of the country can work towards, resolving differences for the benefit of their future generations as well.
Yeah, thank you for that, Chief.
Questioning opportunity is moving to MP Will Amos.
Thank you, Chair. Thank you to all of our witnesses. Really appreciate the considered commentary. To Mr. Smith, it's great to see you again. First time I think we interacted was around the Arctic offshore drilling review in your community of Inuvik way back in 2011. And I can appreciate from that experience that I had how independent-minded the Inuvialuit are and how important it would be for the Inuvialuit to have control over child welfare. And I wonder if you could speak a bit to the need for capacity to collect data and to do the work necessary on the ground to inform an Inuvialuit-driven approach to child welfare.
Gee, excellent question. We have begun, we do work with our regional education system to gather different data in relation to the students and how well they may or may not be doing, so that we could try to focus the limited resources that we have to improve where they need that help. But yes, what you're touching on, and it relates to MP Waugh's question as well, I think, where you don't have the capacity until you do the research. And you're looking at passing legislation. You can't have the capacity until you have something that you have to work with. So it's, in our view, it's catch-22. We need this piece of legislation for us to move forward as well. And/or we don't have to, because, like I said, under our final agreement, we both have an obligation to work together. And if the system that the federal government has put in place with the territorial government, which is an administrative arm, of this federal government, isn't working, then we need to revisit that issue, at least within my area. So, yeah, collecting the data, working with us on how to do that, and what we can do to start to improve the services and the well-being of the children is something we have been waiting for.
Mm-hmm. So you would agree then that the framework nature of this legislation creates the opportunity that allows to change the channel, if you will, or turn the page on the past approach, and enables a more Inuvialuit-driven approach to child welfare?
And finally, Canada recognizes its obligations as well to be more adequately engaged in proper development of this. And I do recognize this as a framework as well. Mm-hmm. I view this as something that, like any other piece of legislation, it's not going to be perfect, but let's get something in place and let's work on improving it, because it's not going to be one size fits all regardless. And our region is going to have different needs and views, etc., than other jurisdictions. So, yeah, let's get to work, basically.
That's very helpful. I think that's reflective of comments we've heard from the Nova Scotia Mi'kmaq. And I'm not sure if I heard from the side of the Inuvialuit specific thoughts around funding. This is an issue that's come up repeatedly, so I wanted to get your sense in the context of framework legislation, which is meant to open the door to a range of different approaches to child welfare in Indigenous communities, with a focus on the Indigenous children themselves and their families, their communities, etc. And would you be seeking a more prescriptive approach to funding, which is outlined in the legislation, or do you think it has to be tailor-made and dealt with outside of the legislation, pursuant to different Indigenous communities or groups moving forward with whatever they want to do?
Well, that's part of what I just responded to as well. But I think the legislation is clear and as vague enough as it could be, as for us to deal with those matters on a region-by-region basis. In the capacity, yes, there's going to be a need for investment in regards to an infrastructure, because, like I said, right now it's a Band-Aid solution where if the government that's operating right now cannot find, a foster parent, then they are sent away. And it's very unlikely that those kids ever come back until they're of age. So that's a problem that we have with the system. So we would like to have the infrastructure that we're operating on terms that we could come to an agreement on, where the children are remaining in the community, or at the very least within the region.
Okay.
Thank you. Wise words. I think that's what we'd all like to see. I want to just recognize that we all appreciate your patience, flexibility. Paul, we've welcomed you. Dwayne, thank you for joining this group. And your comments will be part of the public record. We take them very seriously and really appreciate your cooperation and participation in the process. Miigwech, thank you. And this session is done for now.